Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for his service Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Hope you're doing great on this beautiful podcast Thursday. Had a little business call this morning. Went well. That was always good. Good business calls are much better than bad business calls, but I will take a short, bad business call over a good, long business call any day. Awesome. Wonderful. Good morning. Francis Fitzgerald, congratulations. You were first in chat. And because of that, we're going to punish you with internet ownership. Yes, your promptness and punctuality have been met with a punishment. Everything IP-related worldwide is your responsibility, Francis. But you've been here before. You are, in fact, a habitual offender in this area. So we know that you're up to no good, but you know what you're doing. So, Francis Fitzgerald, thank you very much. True Blue 14 kicked everything off before I even really kicked anything off live here with 10 gifted memberships. True Blue, thank you very much. And Bite Me member for 38 months. OG, woot woot, booyah. Happy dance, stomp on that like button. Buttercup and I send hugs and butter sugars. Rebecca, thank you very much. Appreciate it. You're doing important work now, counting the mosquitoes. But I just ask that you count all the mosquitoes, like all of them, and count them somewhere other than where I live. I don't like mosquitoes. They're my least favorite bug, right next to cockroaches. All right, welcome. Good morning. Are you guys ready? It's day 13. Unlucky 13? I don't know. But it's day 13. We anticipate the state will be arresting today. Mr. O'Driscoll, the lead investigator, is still on the stand. And it's going to get good. I have to tell you, yesterday, right after Miss Nestor's talked, I was impressed with what she did. But when I went down and laid down and stared at the ceiling and pretended to sleep last night, I thought it over, and I can't get out of my head the importance of the one bit at the beginning of that letter that she skipped over. And I don't think the jury can either. I'll still give her props. Miss Nestor, Ms. Lewis, Ramos, that whole team, they are fighters, and they are doing an incredible job. I don't think Kouri has a single iota of justification for a complaint against the effort that they're putting into her case. But the things she left out that the state can go back and underline today, or highlight as the case may be, man, that's a doozy. So I can't wait. I'm learning also that when I ate my scorpion pepper pistachios yesterday during the spicy parts and then touched things around my studio, that was a mistake, because I cannot touch my eyes today. Because no matter where I touch, it's like it's been near somewhere where I might have touched with my finger after I ate a pistachio, and it's hot, it's spicy. Speaking of spicy and hot, Thomas tonight on the podcast, he says he's got some of these coming. He says he's got some of these scorpion pepper pistachios, and I'm excited for him to try them because A, I know he likes hot food. B, I know they're good because I've tried them. And the only thing I'm not excited about is he's going to eat them and make it look like it's candy, where I cry when I eat them. So tonight, hopefully we get to do that. Also, we get to finally tell you the story, the massage story, which will probably embarrass me and I'll probably regret telling. But we're going to tell that story tonight on the podcast as well. You've been warned. You've been warned. Do join us tonight, 8 p.m. here on this channel. All right. Let's see. Is Kouri complaining? Not that we know of. Not that we know of. Josh, thank you very much. Josh, appreciate you, my friend. Happy birthday to Bill and... Man. You guys. Bill and Billy I think it's Bill and Billy I. Dana, Grandma of 6, Judy, Mel Graham, Patricia, and Phoebe. Tell me that Bill and Billy I is the right way to say that. Please, please, please. All right. Let's see. Let's sing happy birthday to these wonderful people who are celebrating their birthday so they can kick off their party, which will go all day long, but we're going to sing to them this morning. So everyone, wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. We found our note. We're good. Hold that note. All right, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Bill and Billy I, Dana, Grandma of 6, Judy, Mel, Graham, Patricia, and Phoebe. Happy birthday to you. Whoa. I underestimated how fast I was going to need to speak, but I did manage to fit them all in, which means Bill and Billy I, Dana, Grandma of 6, Judy M, Mel, Graham, Patricia, and Phoebe. Happy birthday. I realize there are many wonderful days. Today is your special day. There are a million places you could have been, and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully, we can return that joy back to you and make your day more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's house, and his grill, Bob Evans, and Cracker Barrel. Woo! First try. It's always a good day when I nail the whole thing on the first try. Redos are not as fun. Speaking of nailing it on the first try, the dancers are doing their thing. Thank you very much. Love the party. The pancakes are ready as well, so get them while they're hot. Happy birthday. I really, truly enjoy celebrating birthdays first thing in the morning. How can you have a bad day after singing happy birthday to somebody first thing in the morning? You just can't. You can't. Unless you're Kouri. Kouri might still... I'm guessing she didn't sing. I'm just put it out there. She probably didn't sing. Why, thank you. Judge Fleischer even weighing in. Says you guys look great. Let me go ahead and pin this new message for when a witness starts here in just a few minutes. We're waiting for a court feed. It's not up yet, but as soon as it does come, we'll give it to you. We also are providing a live clean feed on Top Mark Media for our partners over there and somebody who wants to watch it with closed captioning. It's a little slight delay to make that possible. Red Pen, Red! Gifted 5 memberships this morning. Thank you very much, Red. Help me with the drums, would you? I can't talk and drum at the same time. I would miss a beat. Let's see. Have you ever thought about being a hockey announcer? Funny thing, Sherry. I've actually filmed for professional hockey. I've been a hockey cameraman, which I think is more fun than being the announcer, because the announcer is stuck in the booth with a big stack of papers and advertisements he has to read. Fans, get right now at Portal 7. Get your bagels. You know, I can't. I don't think I could be excited about that, but I love filming it. It's pretty cool. Filmed at the Maverick Center, which is funny. Maverick, the same Maverick that was the gas station in this court case where the drug deal happened. That's the same brand. That station, that company sponsored the arena, so they called it the Maverick Center. They name it after whoever pays the most for a period of time. And did a fun little drone flyover for them way back in the day before drones were regulated, before the FAA really knew what they were and who was flying them. But I flew over, gave them some great aerial photos of the parking lot and everything, and then they had this brilliant idea. And they said, we'd like to do a drone shot where we'll take your live feed from the drone. Oh, somebody's calling. Hang on a second.
Call from Josh Hutchins.
Josh, you interrupted my drone story. It must be important. What's happening? I'm just kidding.
I just called to make sure that your lights were working after my phone call yesterday.
I had to do some repairs. The lights did stop working. I've got the cable right next to me in case it goes bad. I'll jiggle it again.
Also screeners lost power. So
Yeah, and I
guess
heard
my
that was
voice-
you as well.
Yes, so I just make sure.
It's
I guess my voice is that powerful.
It's a good thing you didn't win the internet, Josh, because we'd all be in trouble. So,
Exactly. Okay.
all right,
Bye.
thanks, Josh. Bye. Josh, great mod. Thank you very much, Josh, for your help. Yes, he called in and everything broke. Coincidence? I think not. Anyway, they asked me if I would do a drone shot during a concert where I would fly over a packed parking lot of cars, dip down through double doors that are open, go down through a hallway, pass through the entrance gates, the ticket taking booths, through the tunnel into the arena, out into the arena, and fly up and over and reveal the stage, like go over the crowd and around. It is like the most unsafe shot. I don't even think it's legal in some states to do that. It's in every state. It's a bad idea. You just don't fly over people like that unless every single one of them has signed a waiver and has great insurance. Because guess what? Drones do fall out of the sky. I'm sorry. Some of them are really good. Some of them fall out of the sky, and almost all of them do, especially when you go from outside where you have great GPS lock and positioning and the drone knows where it is to inside a big building where suddenly it doesn't know what it is, where it is. It was a terrible idea. I told them no. They were really bummed about that. So no on the hockey announcer, but I do like hockey. All right. Sorry for that side story. That sort of belonged in the podcast. That's the sort of story we share in the podcast, just not relevant to anything else. Goldfish brain strikes again. Squirrel brain. Yes. Let's see. Where are we this morning? We're about to go back to Park City, Utah, Summit County, where the state is just concluding their case against Kouri Richins. She's charged in the death of her husband, charged with poisoning him with a massive fentanyl overdose. She's not charged with writing a book about grieving for her kids afterwards, but she did that. And the state did share that book, at least the cover of the book yesterday, as well as some texts and the deals about it. Apparently it was written by a ghostwriter. It wasn't Kouri's words. She had some influence in how the book looked and things like that. But when asked, she didn't even get the name of the book right when her mom asked what it was called. So it's a little bit funny, but... All right, I did get a couple links from some people who pointed out that the book is available on a couple different websites. I've elected not to buy it. Had I known it was available, probably, I don't know, 2-3 weeks ago, I might have bought it just out of curiosity. At this point, I have no interest in buying the book. The only copies that are out there are not going to benefit Kouri directly. They've already been purchased once or given away, as the case may be. She had to give some books away because I guess the sales were not what she hoped they would be. So the money would go to somebody else, but still. All right, we are about to go to court. We're just getting the bars in tone right now. The court TV feed, who's a pool camera for the media pool. Just waiting for them to turn on the camera, so we'll bring that up. I will start the recorders. We have 52 days worth of recording left on this drive. That should be enough to finish up this case. All right, and over here. Sort of doing two things at once over here. All right, what did I miss? Anything else? She's going to sell 100,000 copies. First year, first book, brand new author, ghostwriter, 100,000 copies just by just telling the world. Let the world know, and they will come, apparently. EDB also says she did not nor would not purchase Kouri's book. I'm not opposed to the idea of purchasing it. I would have done it, honestly, full disclosure. I bought a tail light in the Karen Reed trial. Okay, I like buying things that are relevant to the trial. I bought a K-bar knife for the Koberger trial. But I'm not opposed to that, but where it is right now and what we already know about it, I'm not going to buy it now. There are too many conflicting arguments. Defense wants to say he was a pill addict and he didn't want Kouri Reed to... Kouri Reed. See, now I'm broken again. Kouri Richins to find them, so he left them in the truck, yet Kouri's buying them for him. Yeah. Who is EDB? Emily D. Baker, one of the pillars of LawTube. She's a spicy a former prosecutor from California. Actually worked with Josh from Courtroom Confidential. They're, I think, closely with them. Okay, Just going live with the feed right now. Or at least down in that same area, I think. Very experienced, very knowledgeable, very fun. She's an incredible YouTuber. So just on the YouTube side alone, what she does is incredible. And I know she's got a great team that helps her out, but she's always been there. Pillar of LawTube. We wouldn't have LawTube without people like her. And it's also spicy. She does like it spicy. She has some fun words. I enjoy watching her. I'm getting my mucking words fuddled today. Yes, I'll read that very slowly. All right, we have the feed from court, so we're up now. I think we're just down to one feed. Let me just double check and make sure that we don't have... Bum, bum, bum. Okay. Let's turn this mouse on. Why is this mouse working on that computer? Somebody make it make sense. Okay, it's doing weird things, but we'll get it fixed here. That's weird. Okay. I'm sharing a monitor that I should not be sharing. Like across two computers. So. There we go. It's all good. We're done now. Okay, sorry, I fixed it. While they work the audio in court. Maybe Megan, maybe not. Welcome to the gallery. Look at that pink courthouse. It looks amazing. Thank you, Megan. Appreciate you being here. OG. In her mind, she's already sold 100,000 copies of the book. Wait for the big one. That was just the trial run, she said. Then just to get ready for the big one. Watch Peter Tragos. He's great on The Lawyer You Know. He's amazing. EDB, Josh Ritter, and Alan Jackson all worked at the same law firm. They did. Love Josh Ritter. Oh, my goodness. I mean, all of them are great, but I haven't ever done anything with Alan Jackson or directly with EDB. I think we might have briefly passed on I don't know, maybe one of Ian's fundraisers one time or something. But I am wearing Josh Ritter's shirt today. Well, it's my shirt, but it has his channel name on it. Ruth Ann, member for 38 months, says, "OG, yes, you are. Thank you very much. Love the red courthouse. Kind of surprised about the ghostwriter. It's kind of funny, a little bit, because everyone's like, sis, I'm so proud of you. You know, you nailed this. You got this. You're an author now. She's like, yep. Just cost $2,500, and they write the whole book for you, and now I'm an author. I'm like, well, it's not quite how it works, right? You can't really claim that without writing anything. Murder Show 66, got my Stream Deck yesterday. Can't wait to use it. Love it. Stream Deck is a lot of fun. Part of me wishes I had another, and I realize that's another 36 buttons, but I can't change what I have on here. I have 76 pages of buttons that run my switch, my whole everything, from audio, video, backgrounds, overlays, channel switching, even starting and stopping the live stream, all happens on the Stream Deck. And I just don't want to mess with that. So I don't add any more buttons to it, even though technically I could add, and it could control 7 different programs at once. Shelly Small gifted 5 memberships this morning. Shelly, thank you very much for your generosity. Do you think the defense will start their case today? Christy, I think they will. And I think it's going to be probably lunchtime, maybe. You don't know Josh Ritter. Josh Ritter is from Courtroom Confidential. Great guy, just amazing. Burns the candle at both ends. I don't know how he pulls off everything he does. Mark York says, or Mark York. So let's, I said Marky Ork. So let's look back according to the defense. Eric is a cheater, pill popper, gummy eating, non-supportive, homosexual, workaholic, liar, illegal hunter, drug stashing, bad Mormon follower. Did I miss it? That was most of it. Mark, let's see what else. No, I think that pretty much sums it up, according to the defense. According to the defense, his friends say something different, and his family says something different. Although some of those things were right, he was found guilty of violating Utah's hunting laws, taking an elk without a permit. That's a big deal, and it does take away your rights to hunt in the state for a period of time, usually for like 5 years on a first offense. There probably was a fine associated, and you surrender the animal and everything else. But yeah, that was probably the worst thing we've heard he ever got involved with, other than hunting the giraffe. We're not a big fan of him hunting the giraffe, but I understand how those hunts, those trophy hunts in some of those countries work, and how, believe it or not, it actually helps not just the community, but the population of animals that they're hunting. Oftentimes the animal that they're hunting is selected because of its age, because of its a condition it has or something. And it gets to the point where it's not really hunting, it's just shooting, right? It's sort of been pre-selected, and you drive up to it, and then you get to select your, get your trophy picture. But not a big fan of trophy hunting. I'm all for, the canned hunts. Yeah, never convinced me of that. Anyone else unable to go back and start where they left off on rewatch now? Very frustrating. Not just RI on all channels. Oh, the YouTube player is not saving your spot? That would be terribly, terribly frustrating. You might have to keep the window open and just pause it. Of course, if you watch something else, then you're out. Let's see. Trying to follow a line of questionnaire discussion in the chat to see where it started. And it's gone. It's gone. Josh Ritter is my doctor's doppelganger. I don't know. It could be him. He's a man of many talents. He might just have a side business where he's an MD. Ghost Rider write in about ghosts, and Kouri goes on ABC4 to take credit. Even actual ghosts aren't that evil. I don't know. I've heard that ghost writing is a thing, and people do it all the time, and this is not out of the norm. But for her family to know that it was a ghostwriter that wrote the book, and she's like, I don't know what's in it. I can't wait to see the copy, and then be at the same time congratulating her for her great work as an author. That just it hit my funny bone. I just had to chuckle at that. Secret wish for official pickle swoop. Judy, you might get your wish. I'll tell you, the switcher I have right now has a button. It has a button to do swoops and swishes, but it's never been activated by the vendor, by the manufacturer. It doesn't. It has the button, but it doesn't have the inside parts that make it work. So we have one button that just won't do it, and it's the button I would use for swoops and swishes. I can make it happen using my hyperdex and a bunch of fancy transitions, but I want it to be incorporated in the switcher. My next switcher will be able to do it. And hopefully, fingers crossed, right around tax day. Ghosts control my channel, says Kurt, but I normally don't talk about it. Press the button. Wrong button. Let's see, Shelley Small. The letter was a play-by-play for her brother to lie to authorities. The brother's going to be on the stand for the defense if the defense calls witnesses, which I think they should. I think they should call witnesses. I would be surprised if they get up and say, no witnesses, the state's burden, they didn't carry. We stand on that. No swoops is a disgrace. I can do it. I can do it. I want it to be perfect. Like no hesitation, no pause, no jitters. And I also want it to be a single button. And right now, I'd have to basically make the swoop, record it on a hyperdeck, call it from a macro on my switcher, and do a transition or a cut, play, cut, back again. And it's not clean. It's not clean. It wouldn't give it the true overlay, because a true swish, you can see the picture behind it with a swish over the top. It can't just be like cut to another scene and then cut back. So I'm very picky about this. I'm sorry, I'm a nerd about that. But yeah, we'll get swoops eventually. What was in the Walk the Dog letter that couldn't be heard? A lot of what the tell Allie to say this could not be heard. Let me see. I just barely closed it down this morning. I'm sorry, I was viewing that a minute ago. There it is. Let's see. We got all the way up to page 3. So page 4 was the information about, I saw a commercial for the Utah Mortgage Company that can help with mortgages. Give them a call, see if he'll do that. The place in Camas. There's this other guy. See if, what about asking Lotto, hey, there's the judge, about doing a mortgage in his name, helping us out. That part's out. One way to get through Katie is going through my phone and finding pictures of her girls with boys, print the copies, send them out to the press anonymously, mail them, don't email them, just basically blast her kids in the media. That part's out. That's obviously quite prejudicial. Don't let her trace it to you. Let's see. This guy's having the My Girls do the first interview with Good Morning America. Please tell Chelsea to bring up that he hasn't been to church in the last 13 years. She has known him. And Eric would brag to her about how much he drank and did pills in high school. Tell Kelsey to say Eric always wanted Kouri to go down for him. Yeah, just that sort of stuff. That's not coming in. The sisters are jealous of her. Don't forget to work on the gun receipts. We haven't heard a thing about a gun. We want to file charges. There's a lot in there. There's a lot. But the jury did not get to hear all that. So, all right. Done talking about Walk the Dog for a minute. Jan says, I need help to make me think I'm not alone. When transitioning from one shot to another in Vision Mix, I prefer a mix rather than a wipe. What would you use? I'm a hardware guy instead of software. So currently I can show you, right? I'll do a mix right here. This is a mix. I mix from one to another. And this is a wipe. You can see the difference? And you can do like a million different shapes of wipes and however you want. I prefer to have a transition to be to not stand out. You don't want your audience to say, "Oh, and there was a transition," right? Like Homer Simpson's star wipe and star wipe. That's going to be, if every time we cut from one scene to another, it does this. The audience is going to be focusing on the transition more than what the content is. So if there's something you're following, if there's a story you're following where the transition makes sense, say for instance you're going from one part of the country or jumping over to another story, you might say, and now back over in, oops, sorry, I did the wrong one. Now back over here, wait for this. Why is it not doing that? I have to do a dip. Oh, it won't do it. Like that. You can transition and swoop that. Okay, I'm done playing with it. But I think I've got an overlay built because I have my graphics on the screen. I think it's not letting me do it.
Bring the jury.
Anyway, do we know who Lotto is? I do not. Basically, I'd suggest doing the least obvious transition possible.
Hello.
And put it together so that put your videos together so that they don't stand out. Just functional.
Because he's the guy.
The fades are, they're a pain in the butt. Also helps to do a shorter.
When we started 110 years ago?
While we wait for the judge, if you do like a long fade, it seems like you're stuck forever in the mud. You can't get there.
I'm trying to have
if you do a short fade, it's not as bad. But all right, I'd love the tech talk. We might have to do that sometime. Let's get ready for court, though. That's what we're here for. 264.
Squirrel finds a nut every once in a while.
264 objections so far by my count. Yes, I'm using all the tech words. Wins court's supposed to start today. It's going to start Smooth Joswy. It's going to start in about a minute, I think. It's supposed to start right now. So maybe we're waiting for
I was kicked back, taking it
just
easy.
Smash cuts. And smash. It's supposed to start right now. Where did the 110
You
sound
are
like
banished from the state of Georgia.
You guys are having fun with those. I forget where was 110 came from. I think it was the last trial we were following, whatever that was.
I got a stubby little pencil.
Might have been the Banfield, the brothers. Don't remember. It was 110 was the Canero trial with the funny judge. The Canero, Paul Canero, right? Okay.
I'm trying to have court. Don't raise your voice again.
Somebody says, I feel like I'm alone and thinking defense isn't doing a good job. Don't be. Don't feel like you're alone. Your opinion is valid, and you never know. You might be right in line with all the jurors. So just because I haven't shared that opinion or maybe don't hold it exactly as you do doesn't mean your opinion's wrong. So I'd like to hear more, though. What parts make you feel that way? That would be interesting. Robin says, I'm a lurker, but not right now. Robin says, I always enjoy all the comments, even though I'm a silent watcher most of the time. The Canero trials is who the person was asking about the Brother Mansion trial sentencing yesterday. Thank you, JR. I don't recall what happened yesterday, let alone anything else. My business call this morning was from my town, right? They called me up and they said, because I've been doing broadcasting their town meetings for them for free. And it's sort of been a little bit of a pain in the butt because they want you to set up in like 20 minutes and then have this big long meeting with great coverage, and then they're like, and now everybody out because we have to do a closed meeting, and then you're sitting there tearing down your stuff. I'm like, as soon as the closed meeting's done, you guys lock the doors and go home. So it's a lot of fast work and hurry up and get it done with very poor equipment that was probably built in the 70s. And so they called me and said,
we're on the record in 231-500-139, State of Utah versus Kouri Richins. Counsel for the state and the defense are present. Ms. Richins is present. May we begin by confirming whether or not there's any legal discussion we need to have regarding the text message excerpt that the defense offered during cross-examination of Detective O'Driscoll at the end of the day yesterday?
Yes. Yes, Your Honor, I think we do. May I stay seated so I can read my...
Of course.
Okay. Just 1 second. Let me pull it up.
Oda Marie, thank you very much for the gifted membership.
If we can all look at it at the same time, I'd appreciate it, Katie.
Are you pulling up the Celebrate one or the... Okay. So...
Thank you,
it's
Joshua.
up on the screen right now. So it starts with Bates number state, STATE, 0335281. And this was produced to us before the state went through and updated the time. So this is on UTC time instead of mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, anyway.
She's complaining.
Hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrite extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrite and extracted by Miss Gibson.
Can you show me the Cellbrite
Yes,
version
sir.
of
We
this?
are. We can, and we're pulling it up right now.
It's a very big file, so what I've done is I've emailed Katie the cover page, and then I'm working on the box download so she can download it.
Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right.
Typically, these are a complete string that has a Cellbrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Celebrite header. Only some of them, not all of them.
I don't know if, is that true? I thought
That's
all of them had the
No.
Cellbrite header.
No, that is not true.
Hold on, let's pause there for a second, because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Ask Scott.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, I mean, we've had CDR-related metadata regarding text messages. We've had some non-bubble related or non-bubble depicted cell messages that have come out of other extractions. But in terms of blue and green bubbles, I thought all of them had a Cellbrite header.
Yeah, I believe that's right, Your Honor. If we prepared an exhibit that comes from a Cellbrite extraction, it has the Cellbrite header.
Right.
There's others where we just, you know, we've got texts from other means. Somebody sent us forwarded this text, right?
Right.
But if
screenshots, for example.
Correct.
Yeah.
If it comes from a Cellbrite extraction, as best I recall, it has the Cellbrite header.
Okay. And Ms. Nestor, I'll give you the record back here in a second, but it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th, so it's from the 3rd.
Okay. These 3 bubbles are the sum total of their text traffic on the 3rd?
No, we have more than 3. There's, just a minute, there's a couple pages to it. It's the last set of texts that they, there's multiple, see, that's the 2nd page. And, yeah. And that's the last text that they had between the two of them before.
Can you go to that one, please? Katie, can you blow up the 3rd one on that sheet?
Good morning, Cornflake Girl. Welcome.
So, as I understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yes, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the daytime information is inaccurate.
Well,
correct?
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected. And I would expect for the Celebrite downloads that we have authenticated and laid foundation for, the time change is baked in.
Consistent across the board.
Consistent across the board.
Right.
So the fact that this is still in UTC -5 instead of UTC -6 or 7 just caused me to question where this came from, which Celebrate download it came from. And I still don't know.
So that brings us to, is there a version of this that has the Cellbrite header?
That's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No problem.
It's very long, so we have to go right to it. Just give us just 1 minute.
No problem.
Oh, are you on a Mac? Oh, God.
Hey.
Our millennial has a Mac, so it may take a second.
Well, this discussion doesn't need to be had with me on the record in front of everybody. If you can have it with each other first and then distill down what the dispute is, if any, regarding the foundation.
Yeah,
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we could work parallel while they're seeking out the foundation information. We could address, well, a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's further objection is that it's beyond the scope of the direct.
Let's handle those one at a time.
Okay.
Ms. Nestor, regarding hearsay, your client's statements are hearsay if they're offered by you.
Right.
Eric Richins' statements are categorically hearsay if they're offered for the truth.
Right.
What is the non-hearsay purpose of these particular text messages?
So we are actually not interested at all in what is being said, and we could do an instruction to that, excuse me, to that effect. What we are trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd. And that was sent the day before. That is connected to the GIFs, whatever you say, that all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called witnesses about it.
Provide a little more context. What is the photograph of and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever. And he sends her a picture of it while he's there, before he gets home that night. That is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning at 8:40 as soon as the police leave. And they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was, the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're trying to explain to the jury. All I care about is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs at the exact same time, and it was sent the day before. And that's all we're trying to do. We don't care about what's in the bubbles. We can black out what's in the bubbles. I don't care.
Why are you doing this through Detective O'Driscoll? Why didn't you do it through Mr. Kotradimos? I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see he sent her a picture the day before? The rest of it we'll do separately.
But that's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why defendant believes it's relevant, and I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any of the metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri? That's all I'm asking. Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture. That's all I
Without the
care
metadata,
about.
the picture is not relevant.
Well, the
You need the date and time.
We have that. No. We do need the date and time, but I'm talking about the. I thought there was more information on the bottom of those things. And
Why are we doing this for Detective O'Driscoll rather than through another witness that can testify regarding the relationship between the file path for the GIFs and the file path for this photograph?
Because he reviewed it and saw it. I mean, I think he can testify to it.
You can't testify to any of the technical relationship that you're asking for.
Correct, and we're not asking for that. That's all we're asking is to say that the picture was sent the 3rd. That's all I need him to say, and he knows that because he reviewed it, so he's capable.
He knows what he saw. How
Right.
does he know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so
But that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it? I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that this witness has foundation to give you the testimony you're asking for. What's the question you're going to ask?
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said yes.
Okay. And then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm not asking him for any
I'm not sure
technical.
that's even a dispute. Go ahead, Mr. Bloodworth.
Let's never come out before on any other witness.
Okay. But go ahead, Mr. Bloodworth.
I didn't have anything, Your Honor.
Okay. Is there any objection to him just saying yes or no to that question?
Yes or no to the question of, did he review Eric Richins' text messages from the?
I think that's already been answered, yes or
Okay,
no.
yes. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
And so if
Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph, Ms. Nestor?
I do want to publish the photograph.
And tell me why the photograph is relevant?
Well, that photograph is already in as part of Exhibit 340, which
It's not in, but we've stipulated.
We've stipulated is coming in.
Yeah, we
next.
haven't seen that yet.
But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in
We've stipulated to it. It's about to come in.
through.
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What?
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see, Your Honor, I still think there's a hearsay problem. Based on counsel's explanation now, I also think there's a relevancy objection. The photo that we've been discussing,
The gravel photo?
the gravel photo, was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publication's the hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
I'm not sure that follows without additional context. Just sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the defense has, the defense has, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping gravel.
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died, yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd, yes or no? Yes. Is this the photograph that he sent? Full stop.
Oh, I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh no, fair enough. I'm not telling you how to testify, and I don't know what he'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand, do we have a common understanding of the limits of what you can ask Detective
Absolutely.
O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't. It's too hard for him to. I mean, I think it needs
You
to.
can't
be,
show the text messages without provoking the hearsay problem.
No, not to the jury. Just to refresh.
Oh,
Because
that's
I think it's got to be. He's not going to know. It's just going to be a weird picture.
understood.
Should we just go ahead?
Are you
and
going to publish the photo to the jury, though?
No.
Oh, okay.
So, we could just go ahead and admit 340 now, because then the next question is going to be: is this the same photo that is in this picture right here? And then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now there's the follow-on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
so
it.
is somebody going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
That's fine. We do have one other issue. If we're resolved with this, I think we're all clear. I know what I can ask and what I can't. I think we're fine.
Okay.
There's another issue. May I bring it up?
Please.
All right. I really need Officer O'Driscoll to leave the courtroom when we talk about this, because it's about specific questions.
No problem. Detective, if you'd
He's been there the whole time.
step into the lobby, please don't talk to anybody while you're out there, sir. Thank you.
He's been here the whole time. Oh, that's great. Dun, dun, dun.
Okay. Thank you, Your Honor.
She doesn't trust him.
I'm doing this out of an abundance of caution to avoid any potential. I'm trying to be very
Opening of doors.
careful to comply with the court's ruling on the motion in limine not the motion in limine, the motion to admit the statements of David Norris.
Not.
Correct.
Yeah.
Our motion to admit that was denied.
Yes.
So just to make the record, the defense sought in advance to get approval we gave notice to the state that we intended to call a witness named Mr. Norris, who would testify if called, that on an occasion in 2019, I believe, in 2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl. He had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Or for Kouri, but.
Correct. The court the reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
The residual.
The residual, I'm sorry, I call it catch-all,
106.
same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand to testify because the residual hearsay exception requirements were not met. It is my desire with this witness to ask him the following 4 questions about his investigation. And it touches on Mr. Norris's testimony, but it's a separate matter. But I just, out of abundance of caution, I am giving you a heads up. So the first question is this. You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got to write.
I'm sorry. I do have these if you want me to email them to you.
No, it's okay. Just
Okay.
give me a moment.
No worries.
Was it prior allegations that Eric?
Any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
So she's got it, setting the trap.
And this is the next question. Within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about about an incident where Eric allegedly asked someone for fentanyl?
Yeah, judge is like, nope.
Want me to read that again?
Sure.
And within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl? And then there's one more question. Let me know when you're ready, Your Honor.
Sheriff investigative team. Give me the last clause one more time.
Who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl.
Okay.
And the final question is, did you or anyone else connected to the investigative team ever sit down with this individual and talk to them? Did you make any efforts to see if this individual was credible or had corroborating evidence to back up their claims? And that's it.
Mr. Blair.
No objection to the first question. Objections to the next 3. This is a transparent attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible. This setup has been long in the making. After the court issued its 807 ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him, and he said he was calling on behalf of, he was calling because defense counsel told him he should call.
Maybe we just pause here for a moment.
Look at Miss Nestor. Oh my goodness.
I don't know that we need to go into any of that. I
I'm not gonna
understand
allow it.
part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I think that's the beginning and the end of the discussion. There's no foundation for the premise of your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
I'm sorry, but I don't understand what you mean by there's no there is validation from the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. There is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded is someone contacting you, asking to give you information about it, and you refuse to interview them.
That's not the question you asked. Read the whole question.
In order to properly investigate.
No. Go to number 2.
That is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation, that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask it this way. What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
Turns the tables.
That's a fair question.
That's a fair question.
It would be reversible error for me to allow that question. There were 2 residual exception rulings in this case. Let's be fair about it.
Right. That's absolutely correct. So is there a way, if we scrub out the reference to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them with information about an interaction with Eric involving drugs, illicit street drugs, and they chose not to investigate it at all, it does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all other possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
Yes.
But
there's the truth.
I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed, and they are like, no, thank you. I think I'm entitled to get that in, and I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible, but I do believe that's fair game. And I'm open to suggestions. Whatever I need to do.
These 4 questions are not it, Mr. Bloodworth. You look like you're about to say something. I'm sorry.
No, Your Honor, as I understand, the status quo is
no.
The court's, I guess this court has sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectionable questions that are maybe more general, less specific, some version of probing the bounds of the state's investigation of the charges. Yep.
Your Honor, no. It's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may be admissible evidence.
When he says no good faith basis,
May I respond?
Yeah, hear me out for a second.
Sure.
it's unethical
Or
for
let me
Ms.
make sure
Nestor
I
to even
understand
say that.
bounds of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record so far, and the evidentiary record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence that's already admitted,
I think it's his knee surgery,
is
right?
a 2016 hydrocodone prescription following knee surgery.
Right, okay. Very good. Now, by the same token, I believe all the admissible evidence of Ms. Richins seeking or receiving narcotics of any kind is already in, correct? All is putting it strongly, but
Yeah.
That is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
Or it would come in a rebuttal case.
Understood. Okay. Which was the basis, among other things, of, not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. Right. So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you are accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis based on the law of the hoops you have to jump through to come under the residual exception. And for purposes of your analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true, and then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not. So I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
The difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office, or Sheriff's Office? My apologies.
Yeah.
He says yes. and then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely.
If you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on, fine, but I'm not sure how that's relevant.
Well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
But it's not being offered for the truth. It's being
100%
offered,
being offered
Your
for the
Honor,
truth.
if
Yes,
I
it
may
is.
please. It's being offered for the same reason they've gotten in a ton of other hearsay in this case by the impact it has on how they did their investigation. They got that in through Woody. That's how they got in Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out.
Careful.
This is the same exact argument. It's how the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor,
Yes.
then the 807 residual exception wouldn't exist, and it wouldn't apply. It does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why the substance of what he told the Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy substance and just say there was an avenue that you chose not to investigate. But I've got to get something in context so the jury understands, hey, you have this road, you chose not to go down it. That was your choice.
I appreciate why you want to present this to the jury, but there are limits on both sides of the V about what gets presented to the jury. And those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence. For the same reason that the state could not argue that we want to get in Hayden Jeff's statements to his sister just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it, would we be having this conversation?
That's not this circumstance, though.
It is the same, though, because that evidence has nothing to do. Here it's even worse because it's inadmissible.
It's inadmissible from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance is inadmissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant, but without the substance, it's not relevant.
It's time to wave the white flag, Ms. Nestor.
We have just a moment.
Sure.
They're not happy, and wow, she fought and even got a little abrasive with the judge. Your Honor, please. Whoa. That was leaving out the juicy substance, huh? Can you imagine how amazing trials would be if we got to watch all of the bench conferences and hear everything? Can you just? This is what goes on at the bench normally. Love it, love it. The judge's understanding of the implications of what she's talking about, and the law, I would say far exceed that of Mr. Bloodworth's. Even to the point where I think the judge might be going too far in suggesting what the objection would be for Mr. Bloodworth on if the defense did raise that
Your Honor,
question.
I think we've made our record on that, and I'll, of course, respect the court's ruling on that.
Let's go get our detective. Yes, the legal back and forth is my favorite part of any trial.
Let me take a minute.
Now he's having second thoughts.
Let me just take 5 minutes.
Thank you, Your Honor.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before we invite the jury?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay. I'll be right back. Thank you.
All right.
I think the judge his decision, it doesn't sit with him very well right now. You heard the sigh, and he's like, taking a break means he's doing some research, right? He doesn't do it on the bench in front of everybody. He might not change his ruling, but he might word it differently. He wants to do a little bit of research, and then the jury comes in. So we're going to be starting about an hour late. The jury's just sitting in the back room wondering what's going on. But what a morning. What a morning. I hope you didn't miss this, because if you did, you have to go back and rewatch it. I'm sorry. It was that good. It was that good. I love these battles. I wish Mr. Bloodworth were a little more up on his game for the battle back and forth. I think that the passion that Ms. Nestor puts into her argument is amazing. I love it. I love seeing that, especially on a defense attorney. And Mr. Bloodworth is sort of doing the bare minimum and often sort of riding the coattails of the judge. When the judge is, questions the defense, well, wouldn't that cause this? And Mr. Bloodworth was like, yeah, what he said. A little too much. I wish Mr. Bloodworth would offer more, and that the judge would offer less. I mean, I'm great with his rulings. I love the judge's rulings, but I wish the judge wouldn't be like the extra man for the prosecution here. I do love it for the spice. I really, really do. It's an issue for appeal. Yes. The judge should be the referee. He should not put his fingers on the scales of justice at all. And even I think in this case, even just offering potential objections, offering them up, suggesting them. So Mr. Bloodworth, wouldn't you guys? I mean, the first objection you'd have would be foundation, right? And he's like, yeah, that would be the threshold foundation, Your Honor. I think Mr. Bloodworth has to be the one that offers that up. He has to be the one that says, Your Honor, here is why we object. Because if they can't think of an objection for whatever reason, guess what? It usually comes in. Very rarely does the judge say, you don't have any objection? Well, I do. It's not coming in. That happens very rarely, and it would only be in extreme cases. But I wish it was a little bit cleaner that way. She has tenacity. It's really good. She tried every way. I mean, at this point in her argument, she is desperate to get this in, right? She knows, I think they know where they stand, especially with some of the phrases that are going to be underlined and highlighted in that walk the dog letter as soon as the state gets back up. That's going to really stick in the jury's mind. They know they're in a bad way. And this would be a big, big help. Huge help. And she is literally practically on her knees begging at this point, right? She has no shame at this point. She realizes that her client needs it badly enough that her image doesn't matter. She's willing to try anything. She's like, Your Honor, I'm open to suggestions. Anything I will try. I'll do. We just need this in. We need this. And I'll bend over backwards and contort my questions to fit the rules of the court. The problem is the substance, the piece she needs is the piece she can't have. And so the parts that the court's willing to give don't work without that piece. They can't stand alone without that substance in the middle. That juicy substance is what she needs. And it's the fentanyl. Apparently the fentanyl is the juicy substance. Oh, man. I do understand the problem for the judge, though. I'm interested to see what he says when he comes back here just a little bit. It's just planting the seed that will never grow. I like that, Alley Cat. Attorney Nestor gets angry with the judge really quickly. The judge did not get offended. And this is one thing I love about this judge. He does not get offended very easily. We have not seen his temper, right? He's told people to stop and said, okay, that's enough. We've had the dad voice out of him. But beyond that, this guy is he's just level-headed. I love it. I love it. Going to be a few appeals in the future. Usually just one, but it's going to have a lot of things wrapped up into it. Can't she call him as a witness? Jen J, the judge said no. The judge said it would be a hearsay issue. He can't testify to it directly, and they can't bring it in through O'Driscoll. So, not going to happen. Not admissible. All right. Thank you. I don't know what other cases are going on, but let's not spoil it here. A lot of people try to watch several trials at once, and they'll watch this one during the day and try to catch up on another one. Let's not ruin it for them. She's going for mistrial. I think at this point they'd be willing to take a mistrial in a heartbeat. I think they were at that point earlier in the trial as well. A delay, reworking some of this, just the way the ball was teed up for this trial, the defense was in a bad position. They were at the 1 yard line, deep in their own end zone to hike the ball. They're in a bad spot, and they haven't been able to gain the ground that they need. Why wasn't the guy questioned by law enforcement? Well, this I don't know the details of. I didn't hear, not all of the motion in limites were argued in the public hearings. Some of them were done sort of off the record, outside the presence of the media. So I don't know the particular ruling on this guy who apparently reached out after talking to the defense or at the advice of the defense counsel, even though Miss Nestor was very shocked by that. You saw her face. She was like, what? Just her head on a swivel when Mr. Bloodworth said that. They said basically it didn't check out. They heard what this guy wanted to do, and they're like, no, thank you. That's nice. Didn't add up. Camilla Juliana, like before the jury's here. Quick, get those likes up. Thank you very much. Appreciate your encouraging of people to like the program. It is free today, and we have. Let me just check how many we have. We have 970 likes already. The jury's not even in yet, so thank you for that. Appreciate that. It does help the channel out immensely. I will say one of the least effective things, this is just a little insider as a content creator, one of the least effective things to do for me to raise the number of subscribers on my channel is to ask you to subscribe. Other people, that works really well for. And I just have to say thank you, because 85% of my viewers are subscribed to the channel already. So there's only 15% of you who, for some reason or another, are not subscribed. And that's great. It's an amazing stat. But I just want to thank you all for clicking the subscribe button. It makes you also able to talk in chat. So thank you. Yay, 1,000. Woot. Aurora says, I have an important question. Would you buy a house from $170,000 that you can move in but needs to fix a couple of plumbing and electrical? This is a tough question. I don't want to buy another house that has the problems that I bought this house with. Tomorrow, our roofers arrive. Hopefully it won't be too loud, but they're completely redoing our roof. It's been 7 years of saving to be able to get to the point where we could afford it. It needed a new roof on day one. Literally had rain, water dripping through the ceiling in the master bedroom and a couple of the rooms. It's been a nightmare. So I wouldn't now. The $170,000 looks really good, especially in today's market. It's hard to get a house for a good price, but if you're a fix-it person, that might be a steal. Just your own personal tolerance. But there's also things, location. What happened this morning, Laura? We had back and forth argument about a couple issues, things, mostly questions the defense wants to ask Mr. O'Driscoll on the stand, and it was good. It was really, really good. It's worth going back and rewatching when you have a minute. The main question is, what's the house worth? Yeah, do your comps. Oh. Metal roof, that's what I have. It's worth it. Gigi, I used to sell metal roofs, and yes, I hear you. They are amazing. They last forever. They're wonderful. I mean, I could do a great, like a lock seam 18-inch with striations, fern green. I used to sell this stuff all the time. But it's 3 to 4 times the price of shingles, so I can just afford the shingles right now. That's what we're going to do. And the shingles have lasted for what? I don't know, 30 years. So bathroom got finished, right? I finished the door jamb. I still have a little bit of trim I need to nail in place on the baseboards in the bathroom. Metal roofing will be insanely loud, just saying. It's through 2 floors and an attic. I might have to mute my mic all day, so we'll see. Metal's expensive. My metal roof I had put on in November was $129,000. Did he tell them you already bought the house? You just want to do the roof, not repurchase the house? Greeners, I started out in the trim shop when I was selling metal roofing. I started out as a temporary employee, packing trim flashing, eave, roof cap, rake, gable, trim, downspouts, you name it. That's where I started. And worked my way up to a regional manager over Utah, Nevada, and Colorado, selling multi-millions a year. It was a great job. Best 9 years up of my life up till then as far as employment goes. My neighbor across the street, my friend KR, he did a metal roof, and he spent $32,000 on it. That hurts. It was just a screw down 3 foot, like 7/8 wide rib type. Fun fact, Todd Rice works for a hunting company in Arizona, not Mexico, named Sonora Outfitters. He has nothing to do with Mexico. Eric would hunt privately owned high fence facilities, not state hunting opportunities. That's interesting. Well, we know he did go to Mexico to do some hunts, though. Right? Usual suspect. You have straw roof. Thatched roofs are amazing. If you can get one of those, that's a talent. Our roofers took their boombox up with them and played awful music all day long. I will tell you, these roofers that we have doing our roof, we hired them to do a patch when our ceiling was falling down in our master bedroom because of the hurricane or the water and everything else. We hired them to do the patch, and they were so quick, I didn't even hear them up there, and they were done. This is going to be more work because they're taking everything off, replacing plywood, putting it all down again. So I think I chose the wrong color of shingles. It's my fault. I chose a light colored shingle on a white house. And that's, I guess, it's like wearing gray with gray, like gray shirt, gray shorts, right? I think I did that. So sorry to my neighbors. It won't bother me because I can't see it, but all my neighbors can. Didn't even know people hunted in Mexico. Well, they do. Some of the best hunting and fishing is in Siberia. Cool. Neighbors not paid equals no opinion. Oh, they have opinions. We get neighbors that come by and give us flyers and brochures to explain how we should decorate our house and how good it looked before. They've even gone so far as to show us pictures of how previous owners have decorated the house and how they'd like us to do that again. And could we please? And they didn't bring their wallet, so we didn't. But was the guy getting paid off to tell the sheriff's office that Eric had said that? There's no evidence that happened. All we know is that he went to the defense first, or defense was his first contact, and then he went to the sheriff's office. I don't live in an HOA. That's why I can tell them to hang it in their ear. Their ear, not their rear. Hang it in their ear. Plus, we did Halloween. We did the lights and the black lights and everything. They should be happy. I'm vindicated. I have a confession to make. I was actually fishing when I called in yesterday, even though I said I wasn't, says Josh. I knew it. Josh. All right, the judge is going to be back in just a minute. He may reverse his ruling or modify his ruling. He's done this in the past. Sua sponte, he's made a ruling and then thought it over, thought better of it, and changed it a little bit. It's what happened yesterday as well. So this could change things a little bit from his answer. I still don't see that this someone was Eric asked me to buy, if I could get him fentanyl or something. I don't think that's coming in either way, but the ruling might change just a tiny bit, or he might just correct it on the record so he's happier with where it stands. Who has custody of Kouri's kids? We believe Katie does. I think they hunt chupacabras in Mexico. Why can't neighbors just keep their opinions to themselves? I don't know. I have good neighbors. I really do. I can't complain, except for the one that entered my house without permission and then let other people in my house without permission either. That one I'm not happy about. But who said they had a sand-colored shingle? Where was that? I had a sand-colored shingle done on a 1,700 square foot for $8,000. I feel that was a fantastic price. $1,700 square. I don't know how many squares we've got up there because we have a 12-12 pitch, which on a tall 2-story house. So the bottom level has 11-foot ceilings, top level has 9-foot ceilings, an attic on top of that that's 12-12 pitch, which means the roof is a 45-degree angle. It's not going to be a fun project. I really hope they have insurance and don't fall. You have to tell the tree story. I think you've all heard the tree story. We'll save it for the podcast, maybe. Can the judge hurry? I'm so antsy, says Ali B from Tennessee. I'm so thankful to live out in the country. The cows don't care if our grass is too long. They actually prefer it that way, Jennifer. They like long grass. Kouri has been making a lot of faces in the last couple days. She might continue. A massage story is tonight on the podcast, Lolo. 8 o'clock tonight on this channel. I don't think Weather Watch knows what he's in for. I love a judge that's willing to change his mind. It means they're willing to listen, and they don't think they know everything. That's great. This is a great description. Uh-oh. Bad weather, severe thunderstorm watch. Should I close my window? Well, we might get one more day of rain inside the house today before a new roof. Yes, the story about the F and the U tree. Yeah, we'll save that for later. Let's see. Wanted the discussion on the walk the dog letter. Charity Dunning. I felt like that examination by the prosecutors went by too fast. I think we might get more in redirect. I don't think they're done with that, and I think they might drag out that point. I'm sort of disappointed in O'Driscoll in his demeanor and how he answers questions on the stand. It does have a little bit of not prepared, don't really care, mixed in with, yeah, I'm doing my job, and we did it right. So there's a little arrogance and a little bit of sort of, I don't know, that he should know, right? I'd expect him to know it, almost as well as the prosecutors. But I would have liked a little more. Hopefully we get it on the redirect. You let them pick the color of your roof? No, I picked them, but I picked a light color because it gets so stinking hot up in our attic, and I thought a light color shingle would stay cooler over a dark color shingles because they're black right now. We're going to a light gray. Just had the roof replaced in the past year for $25,000 due to age of home, over 100 years old. Okay, that's pretty much my story. Needed all plywood replaced. We're hoping that some plywood is savable. Otherwise, it's good. The bid price is going to go super high. We won't know until they tear it off. I'm behind, says Camo. I'm behind, but I would definitely want someone like Nestor fighting for me. She fights for her clients tooth and nail. I like that about her. I really do. Going from THC gummies to Fent, that's a huge leap, but I get where you're coming from. Cops pulled Eric's Doppler report. Eric wasn't seeking opioids from doctors. I know no opioid addicts that haven't doctor shopped for pills. This is a great point, Northwest. If you are a drug addict, the easiest place to get pills initially is from your own doctor. Why? Because you're going to get treatment for something that they can't really see evidence of. Doctor, I'm in pain. Where does it hurt? Right there. Does this hurt? Yes. Ow. Ow, ow, ow. Well, I can give you something for that. I can't see the pain on the outside, but I can give you something for the pain. And initially, there might be a succession of, okay, you gave me ibuprofen, it still just aches. I can't sleep. I'm getting these headaches. It's radiating, whatever the pain is. That discussion with a doctor can get you into the opioid level pills eventually, if the doctor feels that you're telling the truth. An addict would most likely shop that first. Because A, I think it's cheaper. B, it's easier than going to the street to just start taking an illicit street drug. Let's see. Pain will show up in your blood pressure. Every time I get that, Judge is back. We'll save that story as well. Let's see if he clarifies his record or if he just brings the jury in. No, we have an old house that doesn't have either. That's why it's so hot up there. Like 130 in the attic.
On the record in 231-500-139. Counsel, thank you for your patience. I've just handed you a copy of State versus McCullough, 2014 UTF 215. I need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeff's statements to his sister. Pause for a second. I need you all to be very thoughtful about this.
This changes everything. You can't go back.
Unring the bell once this information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Bonsavage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me.
It's juicy.
I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement in a question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do? This information, this statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. And I'm not sure Detective O'Driscoll's that guy. by the same token, to the extent the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Ayden Jeffs to his sister, Aubrey Jeffs, or information received or is told by Mr. Bonsavage, they're going to have to call a witness that had personal knowledge of those statements and then lay foundation for what occurred next. We can't skip steps.
Wow.
Your Honor, agreed. There's a little more to unpack here, too. Because I happen to know that Jeff O'Driscoll's not the witness for this. We would need time to prepare the witness for this. We also have the problem that
we meaning
the state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point, imagine it's not Jeff O'Driscoll, as you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris, or they call David Norris.
Sure.
And they ask, did you call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to information regarding the Ayden Jeff statements and the Nick Bonsavage statements, that would come in the state's rebuttal case. Is that correct?
Not necessarily, Your Honor. I mean, we haven't rested. I think
Fair.
we would like to get out in front of this before a rebuttal case. And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about. And the state would want to continue that investigation.
Oh, wow.
I think I know what you're talking about, but in terms of how it came to be that David Norris contacted law enforcement when he did.
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you.
Yeah.
I don't think so. My only point in mentioning that is it would just take a little bit of time, and it would be necessary. The other point, I think, well, the other objection the state has is under 403. I think in proceeding in this manner is both prejudicial and confusing the jury.
If I let in everything, though, so Norris, Jeffs, Bonsavage, does that ameliorate any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope of law enforcement's investigation, not for the truth.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both that assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think because of the complete incredibility of David Norris's testimony and how David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than confusion related to recorded interviews with Ayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because I I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't, David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect, just because the information provided to David Norris is highly in doubt and would be highly litigated, whereas the information Ayden Jeffs provided is recorded. There is zero doubt about what he provided. And the information that Nick Bonsavage provided is recorded. There is zero doubt. We're not bogging down into some mess of who said what when.
When you say the information, you mean the substance of what David Norris told Summit County Sheriff's Office a number of weeks ago?
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Forgive me. What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once he spoke with a patrol deputy to take kind of the initial, well, I guess there's once a call into dispatch, which was non-substantive.
Okay.
Then there was an initial contact with a patrol deputy, and then there was a contact with a detective.
Okay.
And then we have the affidavits that he'd submitted, that defense has submitted in the 807 litigation.
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Just to clarify, they weren't affidavits. We just laid out a statement of facts in our motion.
Okay.
It's a proffer.
I'm familiar with what you're referring to. I'm a little less clear on
Sorry,
that. Yeah.
proffer is, proffer is the...
I'm not sure the proffer has any impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
Your Honor, the proffers do tie into this in that, the question would be, did this inform your investigation? Yes, we considered all of his statements to include the defense proffers in determining that they were just flat out incredible.
Okay.
So that goes to kind of the confusion argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is the same as the weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
And to put a finer point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need
It's jury confusion.
Right. And
yes.
so what is it you believe they would be confused about?
I think they would...
Spit it out.
I think they would be confused about the effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of Norris, whereas those waters are crystal clear in the case of Ayden Jeffs and Nick Bonsavage. And the waters are muddied as it relates to Mr. Norris very deliberately. And I don't know that, I suspect the purpose is to confuse the jury, right?
As you sit here today, do you have you identified the witness that would testify regarding investigators' knowledge of and response to statements made by David Norris?
I know, yeah, I don't remember the name. I know the patrol officer, I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right? And so...
You would be able to call an investigator, not a lawyer, right?
Right.
Yeah.
So probably 3 witnesses.
Okay. And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Ayden Jeff's statements to his sister? Or, I mean, I appreciate that Ayden Jeff spoke directly to law enforcement in a recorded interview.
Right, that's what we would have to get into. What did you understand, why, with what level of detail, which is extraordinary. Here's...
And there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, Judge, there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nick Bond Savage jail call, right? That entire jail call comes in lock, stock, and barrel. If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice? I think the court, in considering the weight of the various prejudices, the prejudice with admitting versus the prejudice of the Ayden Jeffs and Bond Savage, I think the court needs to in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence and the fact that David Norris's assertion is not at all probative because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case, whereas the Bond Savage statement and the Ayden Jeff statement is highly corroborated with a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation and probative value to the state's response to that theory.
Correct, under the 403 balancing.
I understand your position.
Okay.
If you finished reading the case,
Ms. Nestor, Mr.
have
Ramos.
15 minutes.
This is high-stakes poker.
Yes, it is. I was just
Soundbite.
going to ask you if we could have a little time to meet with our client next door. She's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the substance of David Norris's statements should come in not for their truth but for their effect upon law enforcement and investigators, for their probative value to the defendant's theory of incomplete or incompetent investigation, that by extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Ayden Jeffs and Mr. Bond Savage, not for their truth, but to show what they were doing and how they were doing it.
Can I just get a clarification on the Bond Savage? I want to make sure I'm on the same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Yes, Your Honor. In a March 4th, 2022 jail call between Mr. Bonsavage and an inmate in Gunnison. They're discussing purchasing a PlayStation controller, and they're discussing who's going to pay for it, kind of how to get the money for it. And Nick Bonsavage says to the inmate something like, Carmen will cover it. She just made money selling fentanyl.
So this is already in, other than we
word
substituted the word fentanyl for
illicit
street drugs.
Right.
Oof.
And that's a recording,
It is a recording.
as is Ayden Jeff's interview with law enforcement.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I explained to her, in really colorful language, how dangerous it is. She wants to stay away from it. Who on earth would want fentanyl? And then there's a second phone call where she calls back and asks for the Michael Jackson stuff, and they get into a propofol discussion.
Right. Okay. How much time do you want, Ms. Nestor?
We have 30 minutes.
That's fine.
Thank you, Your Honor.
Anything else before we take a recess, Mr. Bloodworth?
No, Your Honor.
Ms. Nestor?
No, sir.
We'll be in recess until 10:30.
All right. I hate the delays because we want to get the jury in here and get a witness on the stand, but I love the courtroom chess. The judge did it again. 2 days in a row, he comes back in. After making a ruling, he says, stop, let me think about it. Wait. I checked the case law, and I have to check myself. I don't feel good about what I said. Here's what I understand case law to be. In this case, he's saying, defense, you're right. I have to let it in, what you want. But if that is true, then it is also true that I have to let some other things that were kept out for the same reason on the state side. Okay, when you're doing math, you apply something to both sides of the equal. We apply it to both sides of the V here, and I've got to. That's the most I know about math, by the way. Don't ask me any more math questions. The state side has the goods. They've got the goods. The defense has, what could, as some of you said, will probably come off as a crackpot who, wild eyes makes an allegation that has no basis in truth, that can't be substantiated in any way and looks really fishy. Okay, the judge is saying you can bring that in, but then the state gets to play these recorded phone calls about people talking about Kouri asking for fentanyl, or Kouri or Carmen selling fentanyl right around the same time that she got drugs for Kouri Richins, got this big check. That looks bad. That puts fentanyl in Kouri's hands. Okay, that connects the dots. So the decision is Kouri's on this one, and it's going to be juicy. If she comes back and says yes, okay, which I think is the wrong decision for her, because when you look at the scale of who gets the most benefit, if all this comes in, the state wins. Hands down, state wins. Yes, the defense gets a little bit saying, hey, but Eric was looking for drugs. Consider the source. Weigh the source. Look at all the background that the state says. We'll need not just that statement, Judge. We want to also bring in the background, the investigation of who he talked to. We want his text messages. We want his phone. Who called? Who did he meet with? Who did he talk to? Who helped him with the story before he called the police and told it in its various different versions? We want all of that coming in, and these other two. The phone calls would be epic. They've been kept out for a reason. They are highly prejudicial, but under this ruling, the judge says if you get what you want, they also get what they want. So this is high stakes poker, he says. I love it. Shelley Small, I bet the defense is going to backpedal because they don't want to open the door to anything else. This is them losing. They're literally winning their objection. They're saying, Judge, revisit this motion in limine. We want to bring this in. We feel we have the right to bring it in. The judge did revisit it, said, you're right. But we also were supposed to bring this in. It's a poison pill if they're not going to like the taste of this one at all. This could be fire. This could be amazing. And it could also add another day to the trial or more. For the investigation side, that's not going to happen in a day. We might have a week off or something. Which I don't like, especially with a seated jury. So, all right, we have a phone call from Selena. Let's see how this played out in the courtroom. Just one second.
Call from Selena.
Hey, Selena. How are you doing?
High stakes poker. That should be a soundbite.
Who's holding the aces in this one?
I think oh my gosh. I think the prosecution.
Yeah, I'd agree. They've with two recorded phone calls that include the word fentanyl.
If the defense goes ahead with this, I will be very shocked because it's a lot more damning for them than helpful.
I would say if the defense goes ahead with this, I would put the odds of Kouri testifying in this trial up to about 80%, because that would be entirely her decision, and it's a bad one, and it sounds like she's made a couple of them, and she might make another.
She might make another one right now. In 30 minutes, they're going to really go over it with her, apparently. So,
yeah. I realize the defense does get something from this, and it's big. Okay. It's other evidence that Eric was seeking illicit street drugs, fentanyl specifically.
And
that's huge.
Yes, it's so huge. And the investigators didn't check into that guy. That's a double huge thing, I would say.
Well, I think that what they did check in is enough that they're going to be able to paint him as an unreliable witness, because you've got various different stories. So I think the state's ready for that. They're fine. They don't want it in, obviously, but if it does come in, they're ready to both shoot that down and then provide this smoking gun, 2 recordings that are clear as day.
Yeah. Yeah. Well, it looks like I'm going to go and let Kirk call in because he's trying to call.
Yeah, I hung up on him.
Yeah.
All right.
High stakes poker game. There we go.
Yeah, deal me in.
All right.
Thank you, Selena. Appreciate it.
Okay, bye.
Bye. Okay, Kurt, give us a call. Well, let's see, the New Jersey crank. Yeah, why did New Jersey get flack all of a sudden? New Jersey crank. If you're having trouble with the sound, you don't know this, but it's on your end. You just refresh the screen. Hey, Kurt. You ready for some poker?
Hey, man, this is incredible fire. I think the defense is making a mistake. I think your analysis is right. I think the judge is right as well. Rules, of course, go both ways. With the bitter comes the sweet. With the good comes the bad. The rule that applies to you is the rule that applies to me. So you have to take it both ways. And that's how we do things in law, as we should, because Lady Justice doesn't care. Yeah. She just has scales. The scales are the same for both sides. So whatever rule applies to you applies to me, so that we can all have a fair game. And there are some, of course, there are some exceptions to that when it comes to defense, because they have particular constitutional guarantees. Yeah. But putting that aside, all else is equal. So this feels like a mistake, because I think that this way opens the door, and I think it lets the prosecutor get in so much stuff they weren't able to get in before, and puts the fentanyl in Kouri's hands, and that's a mistake. And I would like to note, by the way, that they're talking to their client about this, but this is a decision for the lawyers.
Really?
Because the client gets to make certain decisions, like whether to testify, whether to plead guilty, but strategic calls, tactical calls are for the lawyers. So Kouri can want this or not want this, but ultimately this is the lawyer's call. So if they do this, it's the lawyers that ultimately are making the call, and that feels like a mistake, because I don't know what they're doing.
Wow. That would be interesting. it would be interesting if, however they proceed, if they don't agree. If Kouri feels one way and the lawyers feel a different way, and they go forward. I wonder if that would play out through the faces we see from the defense table. How's this?
Well, I mean, she's entitled to a lawyer of her choice, but she has a public defender.
But you don't get the defense
and
for
so
choosing.
she's not. Yeah, so she's not entitled to a lawyer of her choice anymore because the lawyer that you got. They're great lawyers. So this is the lawyer's call. So if they disagree, the lawyer has every right to say, no, I'm not doing it. You can't make me. You can't make me call a witness. You can't make me put on a piece of evidence. You can't make me ask a question, right? Those are all calls for me to pursue. My job is to represent you zealously. Your job is to decide what you want to do. The client decides what. The lawyer decides how. Yeah. So the client says, you know what I'd really prefer? I'd really prefer to be found not guilty. That'd be great. Fantastic. My job as a lawyer is now to figure out what to do that.
To craft a defense.
And your job is not to control me.
Yeah.
Right. Yeah, exactly. Your job is not to control me. So, I will talk to you. I will pursue multiple angles. I will consider every avenue. But ultimately, it's my call. Yeah. So, if the lawyers do this, it's their call. So
for most of us,
I don't know what's going on.
For most of us, it's easier to think of it in the terms of going to the doctor. You can go to the doctor and say, here are the symptoms. I want to get better.
Yeah.
But
it's the exact same thing.
Choose the treatment,
it's the
right?
same. Right. It's the same thing it's really the same thing with any professional. Mm-hmm. You hire a plumber. It's like, I want my toilet unclogged. You don't then tell them how to do it. You go to a doctor, it's like, my stomach hurts. I'd like it not to hurt. You don't tell them how to treat you. Yeah. You go to the mechanic. My engine's making a funny noise. You don't then tell them how to diagnose it, right? So it's the same thing for a lawyer. It really fundamentally no different. You hire the professional to do the job. They're going to do the job. If you don't like that, you can hire someone else. You can go to a different mechanic, different doctor. That's your call. But, the doctor decides how to treat it. The mechanic decides how to work on your car. The plumber decides how to fix your toilet. The lawyer decides how to advocate your case.
Yeah.
So this is lawyers' call-in, so they should tell their client to sit down and shut up.
Yeah. So tell me this: use your crystal ball and peer into the future, and let's say, for instance, the defense comes back and says, we're not going to ask him those questions. Does Miss Nestor then say, but we would like to put something on the record? And if so, how do you craft an objection to winning the argument that you just had because you don't like the effect it has on the other party? How does that look for Miss Nestor to not be happy?
I wouldn't
with what
put
she
anything.
wanted?
I wouldn't put anything on the record. It's this is the call you have to make. You have to put on your big boy pants. So if you want to defer to the client, that's fine. Obviously, a lawyer can defer to the client on this. So if you want to do that, that's fine. But you then can't obviously go on the record about it because the conversations are privileged. You can't talk about what you talked about with your client or your client talked about with you. You can't talk about that my client was beating the table. You can't put on a record. So you just got to put on your big boy pants, make a decision, go forward, and go with God.
Yeah. What I was thinking more if she makes something to the record, an objection to the judge's ruling in some way, because I know she doesn't like how this ruling came about. She liked it up until the break. Judge came back and said, I reread this case. You're right, it should come in, but not for the reason they asked. I think it was something else. I don't think they even cited that case law in asking this to come in. They were citing other rules of evidence to bring it in, not this case law. And this case law is what opened the door for all of this, if they want to go that direction. So.
Yeah, no, I mean this is just the way the die is cast, right? Yeah. So you found authority that lets you do what you want to do. Okay, great. That's fine. That's obviously law. So you found an argument that lets you do what you want to do. Great. But the judge is like, look, if you do this, it's going to cut both ways, okay? Because I'm going to use the same measuring stick. So if you want this to be the measuring stick, great. But I'm going to apply it to you the same way it applies to them, because fair is fair. And now they're all sad because it's like, but I just want the rule to apply to me because I'm the special. And the judge is like, I don't think so, because this doesn't go to a constitutional guarantee. This isn't, based in, some sort of right of the defendant. So they get the unilateral right to do this because Constitution gives it to them. No. This is just an evidentiary rule, and you want it to be applied, so it applies both ways. And now we want a half hour to go talk about it with our client when it seems like the answer is very clearly don't do this.
Yeah.
So that's what I think. I think that's what I would do as a judge. That's what I would do as a lawyer. I'd be like, you know what? No, I'm not going to do this. The client's like, but I really wanna. I'm like, no, I'm not going to fire me. Oh wait, you can't. Ha ha ha. So I guess it's my decision, and you get to sit there quietly. So that's how I go about it. But I'm hardcore.
Yeah. Kurt, I 100% agree. This judge has been very fair throughout this trial. The way he handles it, the way he responds with, handles objections is just even across the board. I love his demeanor in court. Fantastic. Judge Mrazek is amazing that way. Question for you, though. The state, the last sort of thing we heard from them before this break was Mr. Bloodworth sort of inartfully trying to describe... a news station weather alert has arrived. Trying to describe how that if this comes in, the state is harmed more than the defense. I didn't follow that very well. I think the big loser is the defense.
Talking about. I don't get
that one. Okay, so it wasn't just me. All right. Yeah, he was trying to say that.
Yeah, I don't understand how the state is harmed. The only way the state would be harmed is if this rule was only being applied one way, right? That would be unfair. So if the judge was like, no, I'm going to let the defense do this, but I'm not going to let the state invoke this rule, the state would be like, that's unfair, and they would be right. But if the judge is going to let the rule apply both ways, which it seems like he is, I don't see the harm to the state. It seems like it's a great win. If I'm the state, I'm like, do it. Do it.
Yeah.
Sounds
Mr.
great.
Bloodworth might
Love
have
it.
been trying
Let's
to
go.
bolster his argument to let that second piece in, right? That second call to say the harm was so great by this weird crackpot comment or whatever about somebody, Eric wanted fentanyl, that we have to bring in both of our examples, not just one. I think that might have been what he was going for, but I think the judge would have just viewed everything under that same rule and let them both in anyway. So, Kurt, awesome. Tell me, if we do a dramatic reading of the Walk the Dog letter, can you give me like a little peek into how that would sound so I can make an educated decision about?
Sure. Walk the Dog by Kouri. Walk the dog, but take vague notes so you remember. Guy is saying even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies.
Okay,
so
that's
Eric
awesome.
would have them.
That's awesome. Kurt, we might have to do that sometime. I don't know. Probably not today. I know a lot of people are just trying to focus on what was omitted in court, so we can only look at those 3 pages, but that's funny. We might have to do something like that.
I'm here to help.
Kurt, appreciate it. Thanks for the call.
The defense needs to put on their big boy pants and lay down the law a little bit to their own client. Let's go.
All right,
let's go.
Thanks,
yeah.
Kurt.
All right, talk to you later. Bye-bye.
Bye. All right, good stuff. All right. Let's see. Did he look for drugs, or was he put up to saying Eric was looking? Red Finch, I think that's what the state is getting at. The state is going to try to prove through additional investigation as well, which means they don't have it right now, but they believe that this was something that was fabricated, possibly by someone on the defense side of the case. I'm not saying I'm not at all saying a lawyer put this up to him, but somebody related or on the defense side. So Kouri's family, someone sympathetic to that cause, might be just somebody who was just out there and likes them and was trying to help. But the state's trying to say that this was just, it was nothing. There was no substance to it. There was no evidence to support that this ever happened. As a matter of fact, it's more likely that it never happened. That's what the state's going to try to say with more evidence, with more investigation. But it's good. I'm sorry, I missed your questions. I apologize. There's a bunch of good questions there. Can you ask Kurt if they might be discussing with Kouri about not putting on a case altogether? I thought about that a little bit. I'm more inclined to say that they probably are going to put on a case now.
Call from Angela.
Good morning, Angela, or good evening for you. How are you doing? I guess it's
good afternoon here, 5 p.m. Yeah. I just have to say something that is, now that we know this, what the prosecution is saying, and what you just said about like maybe this guy was like someone told him to say this, etc. you remember that after walk the dog ladder or sometime after that, I don't know how long exactly, but her defense team was conflicted out.
Right.
Like we
They had to withdraw.
Is it because? Yeah, and now I am starting to question, like, when was this? When did they have to withdraw, and when did this guy come in?
So you're saying, is there a chance they're connected? There's some sort of tie between them all?
No way, it's just about walk the dog ladder. No way.
It might have been something
I mean, if it is just
completely harmless for why they withdrew. It could have been something in another case that was going on. I thought they were doing some work with some of her custody stuff as well that might have continued after they withdrew from the criminal side. So it could be just...
But it can... Yeah, but it can also be ethical because, I mean, we can just guess, but, I mean, the prosecution what I got is like prosecution. They know something we do not know about this guy. And it feels like that way for me. And and I'm just wondering, like, when was this guy, when did this guy come in? How does that relate to walk the dog ladder, if it at all relates to walk the dog ladder and the whole, her lawyers withdrawing?
Yeah.
It's just coincidental, and
and it's pure speculation because there's no evidence right now. It is timings. This might be a coincidence. Yeah. It might be, there might be something there, but I don't think we'll ever know for sure. But interesting thought for sure. This guy couldn't get off this case
and I agree with court. And I agree with uncivil law. Please bring it in. I want this in. Can I please? I don't care if it will add whatever many days of however many days, and that other trial that I was looking forward to watching after this trial, which actually starts on Monday, but who cares? Like, I don't care. Please bring it in. I hope they do it. And I also hope Kouri testifies because, I mean, I am sad to say that after yesterday's defense detective testifying, I'm like, I know she did it, but I don't think the prosecution proved it. And it's going to take the circumstantial evidence is like puzzle pieces. And in like, what it tells for me is like 1,000 pieces puzzle.
Yeah.
So many puzzles. And then the jury has to like jump so much, it feels to me at least, in order to put together the puzzle and convict Kouri. It feels to me. It may not seem still the same to others, but it feels to me like that.
Yeah. I see the whole still. I can see the jury reaching a verdict with convicting. I wouldn't be surprised if they also don't. So interesting. Angela, thank you very much. Good talking to you. Have yourselves a great evening.
You too. Bye-bye.
Bye. All right, right now what's happening, if you just showed up, why we're not actually having court. Thomas is texting me that he just got his pistachios, the hot ones. So he's going to, probably, if he doesn't eat them all right now, he's going to be trying them on the podcast tonight. Let's see. Right now, we're staring at the wall because the defense is, I think they're probably done reading the case the judge assigned to them. The judge has changed his ruling from this morning a little bit to say, yes, okay, you're right, defense, we're going to allow you to, if you choose to bring in this testimony from Mr. Norris, or John Norris, who is going to say that he reached out to the police department to say, hey, Eric contacted me asking if he could buy fentanyl. Obviously, that looks really bad for the prosecution. It looks really good for the defense because, look, Eric is a druggie. Eric was using fentanyl. It wasn't Kouri all along. See, we told you. The problem is the state will then get to go in and look at the suspicious circumstances of how Mr. Norris came to have this information or the credibility of any such claim, and there's not a lot there. The state's pretty confident about that. And then the judge said you'll also get to go into some of this other information about people saying Eric wanted fentanyl, but this time it replaced Eric with Kouri. And we've got this recorded phone call, a jail call, of somebody saying that Kouri wanted fentanyl and propofol discussion with the Michael Jackson stuff. And then we also have another phone call that's where we're talking about Carmen. Hit Carmen up. She's got money. She just sold a bunch of fentanyl. And it's the date time matches right up with when she just did a deal with Kouri. So those will all come in if the defense wants it. I think it's the wrong call. Like Kurt said, it's the wrong thing to do for the defense to let that in. If they do it, it's going to get really spicy in here. And I think at the end of the day, Kouri looks worse when this is all said and done. And there will also be some delays. Question, who is Norris? A friend? I don't know the connection right now. Obviously, if they bring it in, we'd probably find out how he knows Eric and Kouri. And I'm sure the state's going to dig into that as well, if they haven't. Bring it all in, says Brittany. Mention it all. It's going to be good. Norris has been excluded by the judge, and that was by a motion in limine. Let me just say, a motion in limine, and this court has had many of them, right? These battles are fought before the trial begins. There are issues that the prosecution and defense look at the evidence and they say, we know we disagree about this one, about whether or not it should come in. And they fight it out. They try to fight it out individually. They can't agree. They go to the judge. They fight it out in front of the judge in the hearings, sometimes lasting days on these issues. They fight out these issues, and then the judge makes a ruling. And he makes the ruling and says, just so the court's going to go fast, it's going to be a speedy process of justice, but it's timely. It's not going to waste everyone's time. I've made the ruling now that it's not coming in during the trial, and it's done. But now, as defense is pushing and pushing and pushing, they're basically opening the door to stuff that they didn't want in before to come in. And so the case gets messy. It gets really messy as we start talking about things that we knew months ago we were not going to be talking about during the trial. And it changes everything. High stakes poker probably egged Kouri on to roll a dice. She's like, bring it. I'll win this one. A little shake from the camera in the courtroom there. It is a very interesting trial. Way better than I expected. Justice for Eric. Is Norris Lotto? I don't think so. But I don't know who either of them are right now as we sit here. Let's see. Propofol is the drug that Conrad Murray gave to Michael Jackson and it killed him because he overdosed him. And that's the drug that she wanted because she wanted to unlive him. Possibly, but the propofol the Michael Jackson was taken was liquid form. Looks like a bag of milk given an IV. I don't know. I don't know. I don't know if she wanted to do the same thing or if she was just looking at options or what was out there. She might not have had knowledge of what it was. Give the jury all the information and let them decide. All the admissible information. If we give them all the information, the jury decides and then it gets overturned on appeal and we get to do it again. Sometimes there's information that just isn't relevant to the case. Yes, it's about the people involved in the case, but it's not relevant to the issue at hand. Why would Eric take 5 times the lethal dose? Talked about that a little yesterday. That doesn't stand to reason.
Call from
Selena.
Hey, Selena. You're back.
Hey, I forgot to tell you one thing before I head back in real quick.
Yep.
So, Kouri's brother is in the courtroom today, and
is it Ronnie or
his phone number was released on one of those documents yesterday, and he got a zillion calls and had to get a new phone number. So,
come on, people.
I'm so proud that you always try to be careful and redact stuff. I was just going to let you know that.
we try our best to do that, but sometimes they put it up on the screen on the court feed, and it's just...
But that's awful. That's awful. I don't care who it is, Yeah. Whose number. So, anyway.
All right. Get in there. Thank you very much, Selena.
Okay.
Appreciate it.
Bye. Bye.
Okay. Let's see if we've got just a moment to read a couple things here. Josh Hutchins, member for 25 months, OG, says, sending this message because it's free and a shout out to the best TV host there is. Josh, thank you very much. Appreciate that. Sherry and Max, member for 17 months. I have a free milestone message. Yay! Mint Brownie, fun fact, thank you very much for this Mint Brownie. Todd Rice works for a hunting company in Arizona and not Mexico named Sonora Outfitters. He has nothing to do with Mexico. Eric could hunt privately owned high fence facilities, not state hunting opportunities. There are some private, I think both in New Mexico as well as in Arizona and Texas, basically all those southwestern states, that private game reserves are a thing. So you could literally go hunting exotic animals that don't live natively in the United States in one of those private reserves. That could definitely be what he was doing. Couple more. The Daffy 9 member for 10 months. Let's get this show on the road. Shelley Small, thank you very much. I bet Mr. Norris was contacted by somebody in the family and the prosecution knows it. I think the prosecution believes that. Let's see if they'll be able to prove that. Starving, thank you very much for your super chat. Let the defense bring it in to opens doors for witness tampering. That's on them. Sylphidia, the more I listen to Bloodworth, the more I feel like he's not that competent and just taking clues from the judge. He also doesn't pay attention. I can't blame him on the pay attention part because I know they've got they're juggling 7 things, witnesses, everything else. But sometimes it does come across as he's just a little bit behind on what's happening, as was defense yesterday, to be fair. Kurt says, my name is Mud, not to be confused with Bill, Jack, Pete, or Dennis. My name is Mud, always has been. Thank you, Kurt. Good talking to you. Shelley Small, I bet the defense is going to backpedal because they don't want to open the door to anything else. That would be the smart thing to do, I think, in this situation. Selena says, I'm heading back in. Love you. I'll talk to you at lunch. Thank you, Selena, for the call. Cheryl, member for 25 months, OG. Let's hear it, OG. I love your channel and community. Thank you, Cheryl. It wouldn't be the same without you here. Appreciate you being a member. Mendy Lou, member for 34 months. Love this trial. It's had it all. OG. And speaking of OGs, look at Paula Mack, 34 months, says work is killing me with this Epic Go Live. I'm cheating and listening today, so I'm distracted. I miss being here every day. All right, that got us caught up. The judge is back. We should get audio here in just a moment. We see I guess we can't really call it the tuft of justice, but because that was reserved for Judge Carroll, but we can see just the top of his head. And we should have audio here in just a moment. Let's see. We've got a text here. Let's see if I can read it before the judge goes live. Hey, RA, first-time caller. I have a theory about the illicit drugs in the Kouri Richins case. Does anyone else think because Eric and Kouri both had many subcontractors on their payroll, they could have regularly been bartering with the drugs in exchange for services? Not that they necessarily had been using the drugs themselves, but that they had kept some on hand for that reason. I know this is not uncommon. It's possible. It gets really messy on your books, and especially in, I'd say, Eric's case, I would say not very likely, where they had open books, they could see the other's business. I mean, that's where they both had access there. So I don't think that was what happened. Here we go. I think Cody would have seen that in a heartbeat.
Back on the record in 231-500-139. Counselor present, Ms. Richins is present. Ms. Nestor, you've had an opportunity to confer with Ms. Richins. How does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll, he's out still, right? He is not the foundation witness because he is not the individual who communicated with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion since it's not him, we will wait and not ask the questions that he doesn't have, because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that. So we're going to wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
Okay.
I think they can get into the substance
And
under the new
if we
ruling.
decide to go forward with that evidence,
I appreciate that. If you make that ultimate decision,
we'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense an opportunity to state on the record, or at least summarize on the record, their strategic balancing of the risks and benefits so that there is a record of that going forward.
I appreciate that, and I think that's probably a good idea for everyone,
Okay, very
including
good.
us.
So, Mr. Bloodworth, because the defense will not be opening the door to any portion of its incomplete investigation theory related to David Norris through Detective O'Driscoll, I don't believe the state would be permitted to respond to it yet. Is that your view of it?
That is my view of it, Your Honor.
Okay. So, as a matter of status quo, we are going to proceed with additional cross-examination of Detective O'Driscoll, correct?
Yes, sir.
Did we reach I'm sorry.
Could we just go ahead and, well, I can just do it through, I think we decided I would just ask him about 340. I'm sorry, I apologize.
Okay.
I withdraw.
I was about to ask, did we reach an endpoint regarding 340 and the photograph?
So the plan is to introduce the stipulated 340, which we'll get in, and then I will ask him if he can identify the photo. If he can't, he can't, but I'm going to try.
Okay.
And I'm not going to get into the substance of any of the bubbles, and I'm not going to introduce the bubbles or any of that.
Okay.
The only thing I'm going to display to the jury will be the picture on 340, and then I may have it side by side in front of O'Driscoll so he can compare and refresh on the one that's not getting introduced.
And to the extent you ask him about whether it was sent as part of text messages between
Only the date.
Eric and Kouri on the date, it's a yes or no question?
Correct. Just
Okay.
on the date, not the time, because I don't want to confuse anyone or require the UTC time or any of that conversation. And the time really is irrelevant to us.
Okay. Mr. Bloodworth,
Although you
anything
said it was
further on that?
simultaneous.
No, Your Honor.
All right. Are we ready for the jury?
Yes, Your Honor.
All
Yes,
right.
Master.
Finally,
We are, Your Honor.
Doug, please.
we finally get to bring the jury in. We have to break out our Judge Newman for this, I think. If I can find it. There we go.
You will bring the jury.
There you go. All right, so the defense basically reserves the right to make this decision at a later point with a different witness, which would insinuate they're going to do it during their case in chief, which would put the state's opportunity to correct it in the rebuttal section of their trial, which rebuttal is only needed if the defense brings something up that they need to correct. In this case, they would. So it's a possible very, very spicy rebuttal that may take some time as they bring this in, and possibly a little break between those. But what the picture is, we're going to see gravel. You're going to see rocks at the Midway house, at the mansion. Excuse me, rocks at the mansion. That was quite the battle, and for them to not really make a decision yet is fascinating. The judge, and I liked what let's see, Kurt, you said it best here. Let me see if I can find it. You often do, by the way. If the judge says he wants you to justify your strategic decision on the record, you might want to think again. He says, make it make sense. Tell me why this is not ineffective assistance of counsel, is what his question is. So, here we go. Yeah, they shouldn't do it. It's the wrong decision for the defense to do that. And it might just be posturing to keep the prosecution off balance. Lots of that happens.
Please have a seat as you come in. All right, have a seat. Thank you. Ladies and gentlemen, thank you for your patience. We will now proceed with additional cross-examination of Detective O'Driscoll by the defense. Detective, let's have you come in the courtroom. Detective, please step in front of Brittany. We'll get you sworn back in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Have a seat.
Exactly. Ms. Nestor, please proceed.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth?
No objections.
Okay,
State's exhibit 3-40 is admitted.
All right. And this was talked about when, I believe it was Mr. Kostradimos, I think, it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top. Okay. So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber. And the other one is our president. And I think there was a third one, but it's, yeah, Mr. Spacey and in a TV program, right? And those are the three GIFs that were talked about. And if you blow up the time that they were accessed, they all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
Right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Kostradimos, yes.
Okay. Can you pull up another one of the photos that is the picture from the house? That's it.
She's trying to make it sound like they were all accessed at the same time, and this
All
was
right.
they were one
This
big
is
text
another
message.
picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit?
It's gonna be so
Thank
blurry.
you.
Look at
All
the
right.
pixels.
And is that also just a closer up view of the legacy mansion?
It appears so. It's very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
And can you take just a moment and blow that up just a little bit so he can read it better? All right. Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure, and it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness, doesn't have it yet. Any objection to that question?
Your Honor, I think the objection foundation, I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed, correct?
Maybe I misunderstood the pending.
Yeah.
That's the question.
So I think.
Can we back up a step? Maybe I'll catch up.
Sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day?
There it is.
When you were reviewing Eric's final communications?
All the texts from his phone?
Yes.
On the day before he died?
Yes.
I don't remember all of them. I remember some of them.
So then, would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Bloodworth?
No, sir.
Okay. The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more and maybe blow that up a little, that photo? Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes,
So,
Your Honor, sorry, objection. Foundation is to the meaning of died, right? He was pronounced dead.
I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay, so were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor, objection. His recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I've just got one more question about the photo, and then I'm done.
I'll take it down and ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you were about to
Yes,
ask.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo's still up on my screen, and the witness is
My apologies.
staring at it.
Sorry. Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Correct.
Oh, my goodness. High stakes poker has turned into a game of go fish. But this is where we live.
One more step. If we could go back to 340, which has been admitted. and pull up some additional gifts that were accessed at that same time. If we
She
could
said it
pull
right.
those up, please.
Sure. There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Who's Farmer
And that
John?
one was accessed at 10:42 a.m. the morning of the 4th.
Yes.
And the one with the champagne is also that exact same time?
Yes.
And the one with the farmer is that exact same time?
Yes.
And we know for sure that the one on the bottom left was sent the day before. Because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect, thank you. Okay, we can take that down now. All right, I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Cochradimos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Foundation.
Foundation, yeah.
Sustained.
How did we get here?
Federal foundation.
Are you aware that there was a search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Detained.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say
What
that
website?
all of those
Google?
searches are believed to have occurred after April 13th of 2022?
Yes, because on the blue phone.
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up, do we have the, do you have that orange notebook exhibit? I can't remember the number of it. Court's indulgence for just a minute, I have the number. I've got it.
We've all got that song stuck in our heads now.
Just one moment, I'm sorry, Your Honor. It's hard to keep all these exhibits straight. Can we put up Exhibit 2-66R? It's admitted, Your Honor.
Orange notebook up on the screen. Let's do it.
Oh, wait, I'm sorry. Before we do that, can we put up Exhibit, 2-66R? That's correct. Oh, we don't have they redacted part of it, and we don't have that.
Scott, 2-66R, please.
Would he be so kind?
He's like,
I
on
don't
it.
want to accidentally put something up that was redacted, Your Honor.
Unplug it, quick, unplug it. There you go.
It's okay.
Now plug it back
One
in.
moment, please. Scott, if we do our normal dance, I'd appreciate it.
Two steps forward and one step back. Okay, doing the normal dance. They unplug it, plug it back in again. It's going to work. We do need an AI-generated image of the judge and Scott dancing, though. I think that's a requirement right now.
2-66R, publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kid's school notebook, right?
Correct.
Okay, and can you fast forward, Katie, to...
It's not a movie. It's a picture.
Keep going.
It's a picture.
Keep going. Keep going. Keep going. Okay, right there.
In
Can
big
you
and
blow out the bottom third of the page? All right, so this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there is an entry that says on March the 22nd, can you highlight that please, Katie? Kouri starts counseling. Do you see that? You need to say yes.
Yes,
something.
sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
Was it counseling for failed authors? What was it over?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if a mental health counselor was part of those, but that's possible.
And I imagine as I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator,
major crime.
You've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
Your Honor, maybe approach us.
I'll move on. I'm done with that.
We still want to approach, though.
Are we approaching or moving on?
Why?
Bloodworth says.
Moving on from the subject matter, no need to approach.
Got it.
We are moving on from the subject matter.
Very good.
All right, you also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed Mr. Richins' obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it, yeah. I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit?
Bring up the vision board, please. I just barely deleted that image off my screen.
Yes, thank you.
Just making room
The
for other
second
stuff.
one, 816R, I think.
This is the mirror that has all the
15?
pictures. And the,
815R. And that's in,
motivational
Your Honor, if we could
scenes.
publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that one's got things
Would
blurred.
you help us out? Thank you. Let's see. This is 8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
that is the one.
And Judge, Katie does have this one if you wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we switch it back to her, please? I'm so sorry.
No problem.
There was a
Scott's
recent
better.
version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie, to show what's right beside it or right under it? Do you
In
see
loving memory.
another in loving memory right below it?
Yeah, it looks like a program pamphlet from a funeral.
Okay.
Marie.
All right.
Starts with M.
Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing texts between Eric and Kouri, Katie, if you could pull up Exhibit 2 dash, I believe it's 9. 2-3. Thank you. That's it. Before you look at that, do you recall trying to determine, investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
All right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had had. I guess it depends on the timing that you're asking about.
Okay, I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination, okay?
Okay.
Can you blow that up? It's Exhibit 2-3D as in Delta. And just let him look at all of them, please, just slowly. Give him plenty of time to read. Can you go back up? I think we're missing that one. There you go, the next page. Does this refresh your recollection? Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it.
Slower. Let him absorb all the texts. She is jumping all over the place. I think she's basically summarizing and wrapping up her cross. Trying to score those last points.
Okay.
Does that refresh your recollection? Do you remember reviewing this series of texts between Kouri and Eric relating to the trust?
I don't remember, and the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Next.
Okay, court's indulgence for just one moment, Your Honor.
If the witness's recollection is not refreshed, they are not able to draw on any knowledge they have or to testify one way or another about it. And you basically have to move on unless you can.
Your Honor, may I approach the state?
In some cases, they would be allowed to bring evidence in.
That's not true.
1, true. Okay, we're about to get an objection. That's not true. It's hearsay. They're conferring right now. We shouldn't be able to hear this. We're about to hear it because it's going to play out in court, I think, if she tries to go this route. Hush.
We're working on something, but I'm going to ask a couple more, move back, and then we may come back to it once she's done looking. So was it your understanding, without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's based on hearsay.
There it is.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it. There may be some foundation here.
Did you interview people, look at documents,
that was Kouri's mom,
review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon his prior answer. You can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. Now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor. Foundation. That's not what happened.
I think your recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion on about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Ms. Staking, from my memory, testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor, is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses,
pollen,
dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay. All right, I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate of Carmen Lauber's. She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second.
Judge says, tell me more before I make a ruling. Might side with the defense on this one. Why can she ask this on cross? There are some areas she's allowed to go in, and so far she's done a pretty good job staying in the lanes where she's allowed to go. Have some water. Don't believe it's cold in the courtroom. The officer tucking his hands into his vest like that is to create space between his body armor and his chest to cool off because they're very hot. They're not fun to wear, temperature-wise.
The relevance objection is sustained. Ms. Nestor, please proceed.
Did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills, in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
Thank you. You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
Mm-hmm. Yes.
Thank you. Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Kotradimos.
And you also reviewed the phone calls. Well, strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up. All right.
All right.
We're almost done. So just to recap a couple of days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years. right?
Correct.
Okay. And during that 4 years
Gotta be
period of
faster.
time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah.
And
So I'll ask and answer.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
Well, they have investigator, right? She testified here.
Yeah.
Okay.
They're a civilian investigator.
Fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right. The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach? Did you find anything
the
else?
murder weapon.
That had fentanyl in it?
No.
Okay. You can't say how the fentanyl was administered, right?
Orally.
Besides orally.
It was
That's
only
all I know
orally.
is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay.
She's striking out.
You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
And on insurance fraud,
We didn't do the autopsy until he died, so we didn't know.
we have not heard any testimony about any representations that Kouri Richins made to her insurance company. Have we?
Objection, Your Honor.
If you put a word to it. Foundation.
Well, foundation also probably then hearsay.
Would you approach her, let's say?
Ms. Nestor is asking about what you've heard about what Kouri said to an insurance company. The very precise answers. 110 years ago. The very precise answers that the investigator is giving as he follows the conversation back and forth are funny. You can't say how it was ingested orally. Other than that, you can't. No, just orally. You don't know what he ingested. A boatload of fentanyl. It's hilarious. She's trying to point out the things that they don't know, right? Point out the gaps in the case, the big question marks that remain even after the state's done with their investigation. They have all the evidence that they were able to gather. But she's leaving room for him to respond to make it look like we do have answers to those questions. Boatload of fentanyl. We don't have the murder weapon. Fentanyl.
State's objections are overruled. If you would restate that question, if you can, exactly.
I will. And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission.
Still forgery.
Reporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection, well, not objection, maybe approach.
Sure.
Thank you.
I think that power of attorney is still being hotly litigated in the civil case. I believe there's a allegation that the power of attorney was forged. We definitely haven't heard evidence that Eric gave her one. All we've had is evidence that Eric was revoking any previous power of attorney, which is standard language for that type of, legal work he was doing. As part of the setup for the trust, he would have revoked it.
Okay, I'll withdraw that question, Your Honor. Yeah. And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
not Eric.
Probably not Eric.
But he could not say that it was signed by Kouri, correct?
Correct.
Okay. I think that's it. I appreciate your patience. Thank you, Detective. Thank you, Your Honor. We tender the witness.
Mr. Bloodworth, within the scope of cross, please.
We've got a lot we can cover here. Bring up Walk the Dog again, and the stuff we left out. Stuff they left out.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Kochodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you
January, zero.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensics accounting experts and minimal digital forensics experts because you have a small office, right?
Yeah, it's relatively small.
Did the county attorney's office become involved in this case in early May of 2023 when me charged Kouri Richins?
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Kochodimos and Ms. Carrington?
Yes.
And is Mr. Kochodimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about, can we just lay out all the information, all of the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know. She had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And
we didn't even get into that until well after.
And did it predate any of Mr. Kochodimos' investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you recall whether that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Need my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're...
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
Just here to this building.
To this building.
To meet with prosecutors or talk with her attorney. They're here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No. It has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey that says, idiots, idiots everywhere. Is that from the TV show House of Cards?
From my understanding, yes.
Thank you.
House of Cards. Did he sit down? Is he done?
I'm sorry, is he finished? We have no further questions, thank you.
May we release this witness?
Yes, Your Honor.
Mr. Bloodworth.
State rests.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
Thank you.
Thank you, sir. Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it, so if the state could, I think we've marked it as 865. We'll admit that now.
Okay. Can I see it for a moment?
There's no objection here. I think this is what we agreed to, right?
Your Honor, ma'am.
Please. Do you want me to give the Mujisik and stipulation of fact preamble and read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now, during jury instructions, when the court would instruct on that, we can read this
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. State's Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Bloodworth.
There it is.
Your Honor, state's in an interesting posture.
Do you need a moment on the record outside the presence of the jury?
We do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day.
Let's go to early lunch.
Are we going to be able to, it seems likely to me, you tell me, that we'll be taking a recess now but not coming back for about 90 minutes. Does that sound about right?
Your Honor, that's my sense of it. I'm waiting on a defense decision.
Okay. Well, in either way, I'll bet you a steak dinner it's going to be about 90 minutes, but
Chris,
we're going to rise for the jury, and I'll send out word through the bailiff.
All rise for the jury. It's a lot of steaks.
The high-stakes poker game now has transitioned to actual steak dinner.
We have lunch coming today, right? Okay, very good.
Lunch is coming for, I believe, the judge and the jury.
I just think they appreciate knowing. Have a seat, folks. Thank you.
Now he's making them make
All
a
right, Mr.
decision.
Bloodworth,
now.
we're on the record. The jury is not present. Tell me what's up.
Your Honor, the state's waiting on the defense's decision regarding the Norris matter, because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that they did not open the door to this issue through any of the state's witnesses,
you have to go second. It has to be rebuttal.
The state's case of chief so far. I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeff's statements and, forgive me, the other gentleman?
Bond Savage.
Mr. Bonsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay.
Boom, there it
With
is.
the state having rested,
Look at that
Ms.
smile.
Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
This is the judgment of acquittal. See if Mr. Ramos brings his day one game or his dialed back game. Obviously, he's addressing the judge and not the jury, so be respectful. Three-piece suit today.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or any count thereof upon the ground that the evidence is not legally sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage count 4 insurance fraud is that Ms. Richins, or rather True Stage left a voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl, that Mr. Crozier did not provide fentanyl Rather, he provided prescription-grade oxys. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl?
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level, non-prescription pills were going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer your Honor's question.
Okay.
Count 3, as I understand it, is that Ms. Richins, again according to the criminal information, had indicated a phone number with an incorrect digit. The signature on the application that purported to be Mr. Richins is a forgery. We talked about count 5. And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree. Or the
P.O. box, circumstantial evidence that Eric didn't know about it?
Not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that P.O. box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer your Honor's question. Also an interesting point. Term life insurance. At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. If I bring that up, I think that's an interesting point.
It's going to get shot.
Obviously, it was marked for $100,000.
It's considered in divorce.
Value
in divorce
of that,
when you're splitting assets.
I don't know, it raises an
not
interesting
a death.
issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, that I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. Coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, one. Even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else, I believe that the evidence is scant. Your Honor has a question.
No, I'm following.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count 1. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all. Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the Code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Mr. Ramos takes 12 and a half minutes to make a directed verdict argument. The state will now speak to that. probably keeping it short.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts, especially 1, 2, 3, and 4. Speak to count 5 if you want to.
The forgery.
Specifically, Mr. Ramos's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000, well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Ayden Jeffs and Carmen Lauber for drugs of some sort, at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when, she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence, in the light most favorable to the state, that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly, and this is, of course, if Mr. Bloodworth wants to respond to this, I did neglect in my argument initially as to count 2 the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor heard that, so I would just add that for the record.
Understood.
Thank you.
Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be in recess until 5 of noon. Thank you.
All right. I think the judge is going to do what we expect, or what most judges do in this moment, and they deny this motion, because if there's any evidence going to each of these elements, they're going to be allowed to go on to the jury. There's a chance, he said the 5th one, might be convinced. Talk to me about that 5th one, that forgery situation. But he listened to about 17 minutes of argument back and forth on this one. Only needs 5 to collect his thoughts, or copy and paste his response from his previous JOA response. Probably going to be denied. I'll tell you that some of it is definitely going to be denied. Most likely all of it will be denied. It is fun and exciting. Props to Mr. Ramos for putting out a good argument there. He's done his homework. I didn't the part about the life insurance policy having no value. I believe that was a ruling that had to do with the splitting of assets, like if we're in a divorce situation. When there's a death, obviously term life insurance, you can't cash it in before they die. It's not like whole life that as you pay into it, it has more and more value, and then you can like cash in your life insurance policy and get a small amount back instead of waiting for the inevitable. It's really the only way you can profit from your own life insurance policy without dying. But term life doesn't have that. And so he's using that legal finding that term life doesn't have value at the time you purchase it to say, thus, she couldn't have been intending to defraud if there's no value with the forgery of the true stage life insurance policy. Interesting. I think it's a workaround. The law will have to be fixed on that one, but Judge is cool and sharp as a judge on a judge on the bench. Yes, amazing judge. Using the power of attorney to refinance the house without Eric's permission and his revocation is circumstantial evidence of forgery. Well, the revocation, I don't think he ever signed that, right? He didn't want Kouri to know that this revocation was going out. I don't remember how that ended. Did he sign it and put it out? Or just sign it and not tell her? Shelly Small, do you think we're in court on Friday? Let me check, actually, what contact. She sent me an email this morning from the court. Whoa. Holy cow. Jackery's gonna fix my battery. That's cool. Way to go, Jackery. Let's see. Let me find her. All right. Oh, she just, never mind, it was something else. She sent me the pool photos for the day in court. The pool photographer took 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 pictures. 12 pictures today. Shelly, I'm not sure if we have court. I know we don't have it next week. Next week it's only Monday through Thursday, but I'm not sure if we have court this week on Friday. I'll have to check on that. I believe he did not sign or file it initially, but that he had conveyed his position to Kouri, according to Eric's sister. Oh, Amanda, that's terrible news. Will the judge dismiss? Will the defense put on a case? Will Kouri testify? Find out next time on the next episode of not Dragon Ball, but have to come up with another name that's not copyrighted by somebody else. Spring break next week for the courts? I don't think so. Maybe just on Friday. It disputes Ramos on count 5 because she was paid already. Definitely puts value to it if she collected $100,000, right? But at the time that she did it is the way the element of the crime is written. Lori says, wasn't the Valentine's Day incident reason the Kouri asked for something stronger from Carmen? That's the story. I don't think we've had direct evidence to say the first one didn't work, I need something stronger like that. But it sort of plays out that way if you just put everything on a timeline and look at it. Candy, welcome. The judge is going to be back in about 2 minutes, I think. He's making a ruling on the judgment of acquittal. That is the motion. It's always, it should always happen in a trial. Right at this point, after the state rests, the defense gets up and says, Your Honor, the state didn't prove their case. And it's called different things in different jurisdictions. I think here they're calling it a directed verdict. But judgment of acquittal, directed verdict, it's all basically the same idea that at this point the state has rested their case. They say, meaning we are happy with what we've shown the jury, and it could go to the jury right now. We're done. They have all the evidence they need. They say, Judge, look at that evidence, and you can see the state missed something. They say, for instance, that Kouri was also charged with driving recklessly down Parley's Canyon. And you know, because you've watched court the whole time, there's been no evidence at all brought in that Kouri drove recklessly down Parley's Canyon. And so they would say, Judge, I move to throw that out because there was no evidence, even in the light most favorable to the state, meaning, if there's any evidence, if it's enough, then, the judge would say, yeah, you didn't prove it. You didn't even prove that she's ever driven anywhere at any time. So, yeah, it's out. And they would dismiss that charge. It would never go to the jury. It would basically disappear before the jury even started to consider it. So they're asking to do that with all the charges for various reasons. Mostly that each charge has multiple elements to it that have to be met by the state. And if one of the elements is missed and the law reads that they have to prove that they did this and this and this, if one is missing, then that gets dismissed. We'll hear what the judge says here now.
Okay. We're back on the record in case 231-500139. Counsel for the state are present. Counsel for defendant and the defendant are present. The issue before the court is defendant's motion for a directed verdict seeking dismissal of counts 1 through 5 in the operative information. It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court and State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied.
There you go.
Ms. Nestor, you asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor?
No, sir.
All right. We'll be in recess until 1 p.m., just confirming that to the extent the defendant will be putting on evidence or calling witnesses, you have a couple in the wings. Is that correct?
Yes, sir.
Okay. 1 p.m. Thank you for your time. Court's in recess.
All right. So it is the court's understanding that the defense will most likely be putting on witnesses. They have not yet decided, other than the one they took out of order during the state's case. But they're deciding a couple things. They're probably talking about Kouri taking a stand just revisiting that issue. They probably talked about it many times before, and they're deciding where to go from here. We've now seen everything the state has, barring their rebuttal evidence, which would only come in if we bring something in. At this point, are we happy with it and think, yeah, the jury won't convict. They can't convict. We think we're solid here. We don't want to mess anything up. Don't upset the apple cart or open any doors accidentally by calling witnesses that say something wrong. Or do we present the defense plan that we've lined up and the witnesses that we have in order? So they'll be deciding that over lunch. And we get to sit and wait. I'm sorry. I wish I had something more fun for you, but that's what it is. How do we come up with an 8-person jury? I thought Florida was the only one that did that, not 12-person juries. What's up with this? We got 12 people, just 4 of them don't decide. They're just extras. Here's what I think is going to happen. Defense has that tough decision if they're going to open the door on that issue, and I think they're going to say no. I don't think they're going to want to do that. I think this is Selena. Hang on, Selena. I'm trying to make it work.
Hello?
Hey, can you hear me?
Hello? Hello, this is Hannah, and you asked me to call you back. Do you remember?
Who is it again?
Okay, I'm with U.S. Funeral Expenses, and based on our records, it shows that you may qualify for a state-regulated final expense insurance plan that's going to cover 100% of your funeral, burial, and cremation expense. Are you between the ages of 50 and 80 years old?
But I'm not dead yet. Yeah, they hung up. Sorry, she called from the same area code that Selena's in, and I didn't look close enough at the numbers. Let's see. Okay, let me take just this moment because we're in a break and it's lunch. I got a phone call while I was out mowing the lawn the other day. I fixed my lawnmower. Okay, I jump started the battery so we could drive it around and mow the lawn. And while I'm out mowing the lawn, I get this phone call from United Van Lines or something, and they've been calling me saying, "Are you going to use the quote? Do you want us to move your material?"
Selena.
Here's the real one. Selena, thank you very much. I was just telling a prank phone call story. I guess I'll save the rest of it for the podcast tonight because it's really funny. Selena, what did you gather here as we the state is rested? It's now on the
state rested. I don't know if you noticed that Miss Nestor asked Kouri's mom to leave the courtroom before the directive verdict. So the tea leaves would tell you that she must be going to be the first witness, and that's what I'm thinking.
She asked her to leave before the directed verdict.
Correct.
Why?
I don't know.
I'm trying to think through my head why it's not testimony. None of it's evidence. What did they say? What did Mr. Ramos say in there that?
Well, I can't even imagine unless she just had a break, just thought of telling her to go out. But it was odd timing, very odd timing.
How did she handle it? Because we didn't see that at all. I think we were probably looking at the judge when that happened.
Yeah, that's why it's so cool to be in the courtroom, because we get to see these things.
So she just stood up and pointed and said, "You out."
No,
what was it?
She actually got up. She got up from her chair and she walked around to the seat where she was sitting, leaned down, whispered something into to her, and then she got up and left the courtroom, and then she went back to the attorney table. I have no clue.
That's weird because at the beginning of the trial, we heard that comment from Miss Nestor when she was saying, Ronnie, you can't be here, and these brothers can't, you can, and then she said to Kouri's mom, "I'll tell you when you need to leave." That was the
she
first
told
day.
her.
She told her.
So doesn't that kind of make you feel like she's going to be the first witness for the defense?
Yeah, maybe. Maybe she is. That would be fascinating. I'd love to hear from the mom. I have a million questions. A million questions about that.
I mean, why else would she be asked to go out so quickly?
I can't think. I've never heard of somebody having to leave the room for a judgment of acquittal motion.
Well,
so it
and
must
I'm
have been
not
something
sure that
else.
she had to leave. He'd started the judgment of acquittal, and then Miss Nestor got up, walked over to her, and then asked her to leave the courtroom. So I'm just thinking they knew it would be denied, and she wanted to get her, ready. I have no clue. I know they said they needed a half an hour to confer with their client. So, we're coming back at 1, so we have a little lunch time, but
yeah.
I don't know.
I don't know. That's
this whole
interesting.
trial, who knows on any of it?
It's great. It's wonderful. I'm absolutely loving this trial. I love the characters, the people, the roles they're playing. If it wasn't somebody's life at stake and somebody, kids without a father, it would all be fun, right? But it is
right.
Serious. It's somebody's freedom on the line. It's the rest of Kouri's life on the line, and obviously Eric, life is over, and there should be justice there. So, aside from that, I am loving this trial. I wish I could take like the injured party part out of trial and just watch the battles.
Right.
Where can I go for that?
Goodness sakes, this trial has had everything and anything we could have wanted, don't you think?
It's been amazing. It's really been amazing. So, big shout out to Court TV. I know they're going through a lot of changes here this week, but Court TV, the pool photographer for this trial, now switching to Law and Crime, who has taken over the pool feed. So
I just saw my hubby joined. Hey, say hello to Warren Armitage.
Warren, where are you at? Warren? I'm looking. Is he in chat?
He just joined as a member. I see him. That's my husband. Hey, babe.
Let me go back and see. Hang on.
Red Pen wrote, "Welcome to the channel, Warren Armitage. Say hello to us when you get the chance." So,
there you go.
Hey, Warren. Everyone sing. Thanks for keeping down the fort. Oh, sorry. You're going to laugh at this, R.A. He just texted me and said he's in the bathroom at the moment.
So don't call in. Don't call in, but
it just now let me chat.
And now everybody knows. So
yes. Warren, have a good time in the bathroom.
On that note, we're going to go get some lunch.
Okay.
Thank you very much, Selena. I'm looking forward to the state's case. I really want to see if they want to go where they have permission to go, but would open the door to some spicy stuff from the state. I want to see if they think that's worth that. I want to see if they want to put Kouri on the stand.
Same.
She wants to testify, and of course, are they going to call anyone, or do we go straight to verdict watch? That's going to be interesting.
Now I'm going to be in trouble when I get home.
Yep, you
He and I, Warren, I'm sorry.
I'm
okay,
sorry.
I'll talk to you later.
We'll see you, Selena. Bye-bye.
Bye.
Once again, I mess up. I said defense state instead of defense. Don't click the StreamYard link. Yes, don't do that. All right, we're gonna take a lunch break, but keep the feed live. I've got to do a couple things with taxes, unfortunately, which are incredibly boring, and also expensive. So I'm going to get that done and get the documents that my person needs to file paperwork on my behalf, so they don't get put in jail and become a court case of my own. So we're going to do that, and then we'll be back. We've got 1 o'clock Mountain Daylight Time, which is 3 o'clock, so 50 minutes for those of you who just are time zone challenged. 50 minutes. We're going to be back. We're going to keep the feed going here, and at the agents at the door. I don't answer when they're knocking. Yeah, I keep saying I don't know who Iris is. Iris? I don't know who Iris is. Yeah, these IRS people. Let's see. I'll be the alibi. Thank you for that. All right. It's been an amazing day. Thank you very much. Thanks to the amazing mods. We're going to be back here in just a little bit. You don't have to go anywhere. You can stay right here and watch the afternoon session, which could be very, very spicy indeed. After that tonight, remember, we have the podcast right here on this channel, 8 p.m. tonight. So basically an hour after court ends, assuming we run the full-time slot. We're going to have the podcast. It's going to be a lot of fun. I think Thomas is going to try some of these scorpion pepper. Hey, Judge. Scorpion pepper pistachios. I owe you a couple stories. Remind me, United Van Lines. I have to tell you that one. We've got the massage story, maybe the FU tree story. Lots of stories tonight. So if you haven't heard those or want to hear them again, come for that. You guys, we'll see you after lunch break. Bye-bye.
You are banished from the state of Georgia.
Hello. I got a stubby little pencil. Have them send someone with more experience.
Remember in the beginning when we started 110 years ago?
Even a blind squirrel finds a nut every once in a while.
When are we going to break for lunch, Judge?
There's nothing in the order that restrains you from talking to cats.
Thank you.
Don't miss the forest for the trees.
You are banished from the state of Georgia.
You don't put a diplomatic plate on a hoopty.
I was kicked back, taking it easy.
If they didn't, I would lose my mind.
In front of the Walmart.
Remember in the beginning when we started 110 years ago?
Bring the jury.
Hush! Now I'm trying to have court. You don't raise your voice again.
Because he's the guy.
Thank you, sir. You're my new best friend.
I got a stubby little pencil.
I'm not going to argue about semantics here.
I saw a chicken fight.
Scratch all that. Oh, that was terrible. I apologize.
Happy birthday. You look good.
Somebody just sent me a video of roaches fighting. I don't know who won.
Hello?
The bar sucks anyways.
Remember in the beginning when we started 110 years ago?
The zombie apocalypse may be upon us.
Is that correct?
Hush! Now I'm trying to have court. You don't raise your voice again.
What more do you need to see?
It's bigger than you. It's bigger than me. It's bigger than all of us. It's not your turn to talk. I'll tell you when you can talk.
Remember in the beginning when we started 110 years ago?
There's nothing in the order that restrains you from talking to cats.
Thank you. Have them send someone with more experience.
You don't put a diplomatic plate on a hoopty.
Scratch all that. Oh, that was terrible. I apologize.
I got a stubby little pencil.
I don't like podiums, Your Honor.
When are we going to break for lunch, Judge?
I'm going to sustain my own objection.
Hello?
Procedural matters, and unfortunately, you have not.
Hello?
Shame on you, sir.
It's not your turn to talk. I'll tell you when you can talk.
If you could just use your words.
Don't miss the forest for the trees.
It's bigger than you. It's bigger than me. It's bigger than all of us.
I'm not a camel.
I think I'm about to catch a whooping.
I saw a chicken fight.
I'm going to sustain my own objection.
Scratch all that. Oh, that was terrible. I apologize.
I was told counsel wanted to see me at sidebar.
It's not your turn to talk. I'll tell you when you can talk.
Hush! Now I'm trying to have court. You don't raise your voice again.
I was told counsel wanted to see me at sidebar.
There's nothing in the order that restrains you from talking to cats.
Thank you.
I'm the one that gets to say that.
This is not Burger King. People do not get to have it their way.
I saw a chicken fight.
I don't like podiums, Your Honor.
What more do you need to see?
Thank you, sir. You're my new best friend. Squirrel.
Not
Hello.
Even a blind squirrel finds a nut every once in a while.
I think I'm about to catch a whooping.
I was
Happy birthday.
I'm not a cat.
It's bigger than you. It's bigger than me. It's bigger than all of us.
How does he do that?
Hello.
Bring the jury.
I was kicked back, taking it easy.
You are banished from the state of Georgia.
Remember in the beginning when we started 110 years ago?
I'm not a cat.
Hello? Hello? Hello?
This is not Burger King. People do not get to have it their way.
It's not your turn to talk. I'll tell you when you can talk.
I think I'm about to catch a whooping.
Hello?
Procedural matters, and unfortunately, you have not.
Hello?
In front of the Walmart.
Hush! Now I'm trying to have court. You don't raise your voice again.
I got a stubby little pencil. When are we going to break for lunch, Judge?
You don't put a diplomatic plate on a hoopty.
I was told counsel wanted to see me inside bar.
Somebody just sent me a video of roaches fighting. I don't know who won.
I'm not a cat.
Hello?
I was kicked back, taking it easy.
Even a blind squirrel finds a nut every once in a while.
All right. I'm back. You guys are going nuts on the commands. Sorry. Turn them off. Y'all don't understand that moderation is the secret to success. Not like good mods are a secret to success, but use the commands a lot, then it only hurts you because then I have to turn them off. So. All right. Now that the jury's heard everything, wouldn't their minds be made up? They haven't heard everything. They've only heard the state's case. They don't know yet if the defense is going to have a case. If the defense has a case, they have to listen to that too before they make up their minds. Can we have slots back? No, you cannot. Do you remember the product you used to clean your screen computer? Like Windex? What? Let's see. All right. Oh, are you talking about to clean my glasses? This one? It's called the Jinkies. Crime scene tape. And I wipe my eyes with them. Is that the one you're talking about? All right, how's your lunch, everybody? Welcome back. We've got just a few minutes here before the judge knows something to clean screens. Tech wipes? I think I have some tech wipes around here somewhere. One sec. They're gone. I have something that's not tech wipes. But I'm not going to show you those. I think tech wipes is what you're looking for. I have the ones I wipe my hands with after I eat chips. That's it. All right. Use Windex, works great. Yeah, I don't use Windex on my my laptop, but I do use it on my iPad, iPhone, and my iMac. No candy wrapper. These are my hand wipes. They're called rinse-free bathing wipes, enriched with aloe vera, latex-free, alcohol-free, extra soft, moisturizes, hypoallergenic, and microwavable. I don't know why you need to cook them, but yeah, if you have a little bag of chips, a little snack at a computer desk, say like you eat some scorpion pepper pistachios, and you don't want everything to be scorpion peppered, then you use one of these. All right. Bidet wipes. No, I think that's like these two words should not be together, right? That's the whole purpose. Bathing wipes. Yes, that's what they're called. Must be tired. Yeah. Let's see. Amazon sells them all. Yep. Jerry, it's sad, but sometimes that is the best possible outcome considering what's going down. I think since yesterday talking to RA and my crazy chihuahua came out, I've been blocked here. No, you haven't. I see you. You're here. We rarely block. I don't think I think during this trial, maybe one person has been blocked during this whole trial. A couple people get some timeouts occasionally just to be like, dial it back a little bit. But usually it takes a lot of work to. I mean, trust me, if you want to, you can get blocked, but not many. Maybe the mods are like one. Try 20. I don't know. I've only seen one. It was a bot. Yeah. All right, let's make it 2, says Cody. Yeah, we don't block people very often. Yeah, there you go. It was one. It was a bot. That was it. The mods are really good at finding that, and they're really good at moderation in their response. So, hola from Mexico. Sorry, I tried to do an accent and butchered the name. Mexico. Did someone call yesterday reported a varmint in their toilet? Yes, they did. I am Super T, gifted a membership. Thank you very much. I am Super T. That's very generous of you. We've got about 15 minutes before the judge comes back, and defense will sort of tell us at least some of their plans going forward, what the rest of today looks like. It could involve calling witnesses. Today. We might hear from Kouri's mom. We might hear from Kouri's brothers. We might hear from all sorts of people. We might hear from Ivan Victor, who's on the phone right now.
From?
Ivan, how are you doing, my friend?
Well, I'm a little bit nervous, all right?
Why?
So,
for your girl, Kouri?
No, first of all, we'll get to that.
Okay.
First of all, I missed this morning because last night my wife made lasagna, and I ended up eating it, and I slept for 10 straight hours. And now I'm starting to wonder.
You ate the whole lasagna. You ate the whole thing.
Well, I'm starting to wonder if there's anything in the lasagna. Okay, so I just sent her a text asking her if there was fentanyl in the lasagna. And she said, stop watching Recovery Addict. I'm not trying to kill you.
Just asking. Yeah.
Well, I was the only one that ate the lasagna. And I slept 10 straight hours. So,
that's a good.
Anyway,
let me spill the beans here, Ivan. I happen to know a little bit about you, and I happen to know that you sleeping 10 straight hours might have something to do with you staying up for like 32 straight hours before that on Twitter. Right?
These are all.
And I know, I see your tweets. You're all hours of the night. You don't sleep.
Listen, you got to get your ammo off whenever you can.
Yeah.
So I missed this morning. Let me
catch you up.
Give me a short recap here, so I don't have to.
All right. This morning,
through it.
No witnesses until Detective Driscoll came on the stand just about an hour before lunch, and all the morning was taken up with some pretty spicy argument back and forth about what the defense wanted to go into with Mr. Driscoll. They got shot down, and basically the state won everything, like they have recently in all these little objections. And then the judge said, wait, let me go back in my office for 5 minutes, came back out, changed his mind and said, yes, you can go into it. But if you do, the state gets to go into what they want to go into, which and all this has to do with people reporting that they had a conversation with someone and it included the word fentanyl. The defense wants to say there's this guy who called up the police and was like, hey, I just want to let you know Eric came and asked me for fentanyl. This one time. That would be big for the defense.
What a convenient little
surprise.
Dropped off.
Yeah, so it's very suspicious. The police did not take it seriously. I mean, they looked at it, but then they dismissed it for a number of reasons. But we can't go into that yet because we haven't got there yet. The defense, if they bring that in, the judge says, then the prosecution gets to bring in two people. One is a recorded jail call, and the other's I forget what the other call is, but they're both recorded calls where one of them says, hey, if you need money, Carmen Lauber should be able to give you some money. She just scored some major cash selling fentanyl, and it's right like on the date where she hooked it up. Kouri.
Well, this is the problem I've always had, R.A.
And then there's another one with Eric's friend. Remind me what this one. It's bad too. It's bad too. I forget. There's like two recorded phone calls where they use the word fentanyl specifically, and they talk about fentanyl and propofol on that one, the MJ stuff. Like Kouri's asking Eric's friend for the drugs in this call, so it's bad stuff. No, go
I have 2 points of contention with the state's case. First of all, I feel like once the police, this is what I don't understand about the comparison. Everybody is up in arms about the walk the dog, which fine, it doesn't look great. But I want to know what the actual difference in behavior is from her messages in the walk the dog letter supposedly are. She's basically telling them what to say. How is that any different than the police telling Carmen, tell us what you want to tell, what we need? It's the same behavior. It isn't written out in some goofy letter with codes and doodles and stars and all this, but it's literally the same behavior. It's do what we have to do to get here. And so to me, it's the same behavior. It's the same behavior it's actually worse from the detective. They said, give us what we need to convict her. And so to me, when she's telling her brother, say what you need to say, it's the same behavior. I understand it looks worse because it's the defendant and we give such a long leash to police and they're allowed to lie and they're allowed to this and they're allowed to that. But to me, and I know Carmen's not on trial, but it's the same behavior to get to the end result. And to me, I feel like they should wash each other out. If we're going to give so much weight to one, then the other needs to carry the same. And so the second part is this notion that it takes $3,000 to overdose is just absurd. People overdose on $40 every day. And so where are the other drugs? You didn't just use the exact amount of drugs that it needed to kill him. There are drugs somewhere from all those deals, and that matters, especially the drugs bought after the death.
Yeah.
So,
here's what I've got, and I quote. This is Kouri. Here is what I'm thinking, but you have to talk to Ronnie. That's her brother. He would probably have to testify to this, but it's super short, not a lot to it. He will need to tell Sky at the meeting next week upon information and belief, just like they say.
Yeah, it looks bad. I mean, I'm not.
It's terrible.
I get it.
I'm
not trying to say that it's not. But I'm just saying that I want to know where the other drugs are. If that means Carmen has to say, yeah, I took some, which I already know she did, then do that. But to me, if I'm a juror, I'm thinking, wait a minute here. I'm a juror. I have a kid with a drug problem. I know my kid's friend OD'd, and he ain't never had $3,000. Why on earth did it take all this money to kill Eric Richins if he didn't have a habit? I don't understand that. And I don't think he did have a habit. I just don't think it's strange. It's strange that there isn't one pill found. There isn't anything found. And Eric, the guy who supposedly has no tolerance, took $3,000 to whack him. He's got an iron liver, apparently. I just don't get it.
I think it would have taken much less. I think probably an EpiPen could have saved his life before from an overdose. And it was probably a lethal amount at that point. We've got testimony that he used an EpiPen, right? So he's OD'd once before, and then this is the second time, and it was even a stronger dose. I mean,
here's a PSA: don't use an EpiPen if you're not dying. It's a bad time.
It's not a trip.
It will not do what you think. So that's just my PSA today.
I just can't get over the needle. Jabbing yourself in the leg. I mean, I'd need somebody to hold me down and do it themselves. But
right
the
on.
Google
Right.
Voice switch phone feature is no longer available.
I'm going to rip apart this lasagna and see if there's anything suspicious before I heat it up. So, anyway,
Epi is not Narcan. All right, Ivan. Thank you very much. I appreciate the call. Good luck. I hope the lasagna is safe and you can have seconds and not worry about your future. So,
all right, I'll let you know.
I love you, man. See you. Bye.
All right, love you. Bye.
All right, Epi is not Narcan. I was confusing the two just briefly in my head. I'm with you. Sorry, I hit the
Call
wrong button.
from Cornflake Girl.
Cornflake Girl, how are you doing? I saw you in chat earlier this morning. How are you doing?
Hi. How are you?
Fabulous. What's on your mind today?
Well, I wanted to weigh in on Ivan's question about what happened to the other drugs. Okay. Wouldn't it be reasonable that Carmen sold extra pills, and that's why she came into so much money? I mean, $1,000 isn't a lot of money. I mean, maybe to her it is, but...
Here's what I think. I don't think Kouri is a pill-popping drug addict either. right?
Right.
I don't think either Kouri or Eric were. THC gummies, sure, fine. But as far as the pills, no. This was a world that was not familiar to her. And when she asked Carmen for the drugs, and she got the money, I think Carmen knew that she didn't know much about drugs from the way she was asking. And Carmen milked it for all it was worth and scored big time on that. So Carmen cashed in on this transaction because Kouri doesn't know the value or where to get it, right? She's desperate. She wants this. This is my personal opinion.
Yeah. I mean, if she had 30 pills, she could have given 15 to Kouri and sold the rest of them.
She could have split half with the driver whose car and gas they were using to go down to pick up the pills. And we know that the driver took some. We got that testimony in.
Yep.
So the number of pills that Kouri ended up with might have been very different than the number of pills that Robbie handed across in the baggie.
Yeah, that's what I'm thinking too.
And that changes the math because Robbie's math was different than Carmen's math about how many pills there were. Carmen's saying how many pills there are based on what she gave to Kouri, not what Robbie gave to her.
Right.
I don't know how many were left, but...
Well, if you hear banging in the background, I'm having my roof currently done. So.
Well, when they're done with your house, they're coming to mine tomorrow.
Okay. All right. Thanks for taking my call.
All right. Thank you.
Take care.
Bye.
Bye-bye.
The real question is, what constitutes a boatload? When I think boatload, I think more than personal consumption amounts, right? Even more than personal consumption over a lifetime of usage and abusage. A boatload is actually a boat load. Let's see. What was found out about court tomorrow? Cure Fan San Diego, I don't know. I looked at my notes. I don't have anything that talks about tomorrow, although I have next week. They show that there's no court on Friday. We might be done. Might be done with the verdict by then, but it's blocked out right now. So we basically have to wait till tonight for the judge to say, okay, have a good, long weekend, or we'll see you in the morning. And that's when we're going to know. Let's see. A boat in street fentanyl is 1,000 pills. Is that actually a term they use? I need to buy a boat. A boatload is a butt ton. A butt ton is an actual term of measurement, too. That's like legitimate. I need a boatload of fruit snacks. Only funsies, we buy them by the boatload at Sam's Club. And no matter how big a box you buy of fruit snacks, my kids are determined that it is 1 day's worth of fruit snacks. Picking up wrappers all over the house. It's nuts. You're going to need a bigger boat. Let's see. There's no scheduling out for tomorrow. I know they were taking Fridays off, but then I think we worked one Friday. Right? I seem to remember we're on, what, day 13 now. How does the math add up? I don't recall off the top of my head. They don't OD on the fruit snacks. But by OD, do you mean sugar high, run around the house crazy, tear all the cushions off the couch, make a fort in the front room, and then leave blankets and pillows and Nerf darts everywhere? Yes, they OD. They OD on the fruit snacks. How big was the box of? This was a response to big. Sorry, that was my own question. I was just answering. That was silly of me. Nestor has a Tyler Robinson hearing on Friday. Okay, that could explain why they're taking the day off, possibly. Eric's liver showed zero evidence of being an addict. Yes, correct, right. And if he was a pill-popping addict the way Kouri describes it in her later recounting of the stories, not her earlier ones where she says he never used drugs, there would be some evidence. Drugs are hard on the body. It shows up, and there's evidence. Let's see. We were in court the first Friday. Nurse Kate, I think that was right. That makes sense. Now he's getting commentary from himself. Oh, man. All right, the first Friday was on. I turned off the things. I did. It got to be a lot. I wish I could set the timer to be a little bit longer on the commands. 1 minute is just too soon with how many commands. It's just nonstop noise, which sometimes it's fun, but it can be a lot for somebody who's trying to lurk at work and watch for court. I am a grandpa almost, about a month. I will be a grandpa in a month. Give or take. I don't know the exact date. I should probably know that. All right. Kurt is doing a dramatic reading. Let me take a look at this. Of the Walk the Dog letter. Nice. After our show today. We have a podcast.
Donald.
Oh, let's see. Donald, this is R.A. How are you doing?
Good, and you?
I am doing absolutely fabulous. Happy Thursday to you.
Happy Thursday to you. Yeah. I just want to give you a little benefit of my knowledge. I grew up in the 70s, and when I was a teenager in high school, I did a lot of weed. Mm-hmm. I actually had a drug dealer. And the way we generally did drug deals is, if he didn't have any, I would go to a friend and say, "Hey, man, can your guy get me some weed and that?" And so he'd go to him, ask him, and if he said yeah, he'd come back with a price. So I give him the money. He'd go get the stuff, and when he come back, I didn't give him money for doing it. What happened was either I would get him high so many times, or I would split some of the weed with him. And so I think that's what Carmen did. It just took.
So you basically pay in kind for their part of the services.
Yeah, and I think that's what Carmen did. She just siphoned off some to pay for her effort.
I would say that for a drug addict, that seems like the more logical path. Instead of like, well, I'll get some money because I've got to get lunch tomorrow. Usually the drug addict is looking more for the immediate high, and the option to cash in with drugs now is usually the route they might take.
And then she can sell the pills to get money to buy her drugs of choice. So,
or trade them, or swap them, or just continue the deals. Yeah.
Right. So that's generally how it worked out.
Well, I appreciate you sharing that. I led a pretty sheltered life growing up and had no clue how it all went down. I think I saw weed maybe 2 or 3 times in high school. I saw more marijuana growing up in the mountains, just going up fishing and finding marijuana grows, irrigation, everything, just up in the mountains and the trees than I ever saw at school. But,
well, I grew up in the late 60s, 70s, so it was pretty common place.
That's cool. Well, Donald, thank you very much. Appreciate that. Thanks for the insight.
No,
I hope to never have to use that little bit of information, but thank you.
You're welcome.
All right. Have a great day. Bye-bye. All right. I didn't see weed till I was 26. Let's see. I was going to tell you the end of, because it's 3:03. It's already past time. Judge is going to be here in just a second. I can't tell you the story. All the stories have to wait till the podcast tonight. I'm sorry. I've started like 6 stories and never finished them. That's what happens when we have fun. Proper stoner etiquette. Yes. It's the honor among thieves thing, right? Blackbirdier, welcome to the jury. Thank you so much for your support. That's huge. Now a jury member, you get to move from the hard reserved seat to the soft reserved seat. So do enjoy the improved view as well. Take your place of honor in the jury box. There's the judge. We were expecting him. He's just a couple minutes late.
And 231-500-139. State's counsel and defense counsel are present. Ms. Richins is present. Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yeah, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Look at them, look at each other.
Can we have just a minute?
Yeah.
We have
what?
We have a couple of options.
Understood.
We're ready to go, but we don't know who we're starting with. What was your plan gonna be? That was full on. What, us, Judge? Oh, our turn. We're gonna, like, our witnesses today. We're ready to go. A little louder in this ear.
Your Honor, actually at this time, the defense intends to rest.
Boom!
We should probably do that in front of the jury, yes.
Right.
They're done.
Okay.
I agree.
They're done. They're gonna rest.
Just want to make sure you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of
Yes,
Ms.
testify.
Richins' right to testify on the record?
Yes. Yes, you can.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Shortest waiver ever.
Thank you.
We're getting little
Anything
glitches
further on the
the
record,
feed.
Ms. Lewis?
No, Your Honor.
Mr. Bloodworth, how would you propose we proceed from here for the rest of today?
Sir, let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin. The parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
I don't think we have a problem with that. I thought we were thinking it might make sense to get the jury instruction conference out of the way, and then.
I agree with you. May we do it tomorrow? Give the counsel, both sides, a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
Yeah. Yes, that's fine.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning, yes?
Yes.
Yes, sir.
Okay. Okay. All right.
Wow.
Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
Holy smokes. It was a big bluff. They had nothing. They have nothing. The judge was even surprised by that. I think he honestly thought they were going to call witnesses. They did, technically, I think you can say they did call one witness, but they just took one of the state's witnesses out of order and were able to ask questions on direct. So, I mean, whether you count that or not, I don't know. Oh, they've been posturing that they were calling witnesses all along. It looks like a decision they made at the spur of the moment. No, I think Kouri knew they were not going to. For some reason, this came across as defense trying to surprise the prosecution by arresting. That's it. That's the only thing they'd get from that. Just like the moment of surprise, and the judge sort of took that away from them by asking, "Well, who are you going to call?" And they're like, "We've got some options."
Please have a seat.
Fine, we're going to rest. They wanted that moment. Let's see how it plays out in front of the jury.
Have a seat. Thank you. Mr. Bloodworth.
Your Honor, the state rests its case.
Very good. Ms. Lewis.
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning. I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take affirmative effort and diligence. I need you to use that same affirmative effort and diligence to make sure you avoid watching, listening, or reading anything about this case from any source whatsoever. And please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning. Please travel safe. Enjoy your weekend. I'll see you at 8:30 a.m. on Monday. Please rise for the jury.
Well, well, well. It's time for a poll.
All right, folks, have a seat. May I propose the following? That counsel have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30?
Do you want to do it a little later just so I have time to look at whatever happens?
You suggest late as possible.
You want to do it at 1?
Yes, sure.
Mr. Bloodworth?
Sure, sir.
All right. So you're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Richins, 1 p.m. tomorrow. The court is in recess. Thank you. All rise.
Wow, that was quick. That we we're talking about what's going to happen next week on a Friday, and so now we're talking about jury deliberation on Monday. So this is going to be good. Let's see, where's the call? Hang on. Hello.
Hey, it's Uncivil Law again. Are you not entertained?
I am. This case ended with a bang. It got spicier and spicier and better, and then boom, we're now to the point where the jury gets to weigh in and make all the decisions. So
I respect the defense's choice. I don't know that I would do it in the circumstance. It's a big boy call, and I don't think I'm equipped to second guess that decision right now. But I don't know that I would do it, but I do respect the call. I feel like the state fell short. We've sort of highlighted why, at least in my opinion. I feel like the causal connection of getting the fentanyl into Kouri's hands is the weak part of the case for me. We've sort of discussed that at length, so we don't need to, batter that issue. But they feel like the state didn't make the case, and they just want to put the state to their burden of proof. Feels like they didn't make it. So big boy call, but I respect it. They had, they had witnesses teed up. They had a case they were thinking about making. They wanted to prep for multiple different contingencies, as one would, right? So they had a whole host of witnesses. We don't know which ones we're going to call. And at the end, when they finally had to make the decision, they're like, we don't really want to call out any of them, so, so be it. I will chastise the judge slightly for the shortest colloquy on the defendant's rights ever. I think that should have been a bit more verbose.
Give me 2 or 3 minutes. Give me like a little bit of back and forth. I need you to verbalize what that. What does that mean to you? Are we talking about the same
a little
thing?
bit more. Yeah, normally you ask that question, and you've heard it multiple different times. Usually that takes a good minute or 2 minutes to go through that, as it should, because you want to make sure, do you understand the other right side?
In some states, they'll use that same time to basically cover. Are you satisfied with the representation of your lawyers? I mean, they'll go way into it. But this was just. I also didn't like the way that second question was phrased. Are you following your lawyer's advice as to not testify? I didn't like the way that question was phrased, because that's implying that the lawyer's advice was to not testify, which we don't know. Yeah. And then Kouri's answer is ambiguous, because it's like, this is putting on the lawyers that they suggested she not testify, which, to be honest, they probably did. Yeah. But still, I don't like the way that question was phrased. When they rested in front of the jury, the lawyers sort of threw it back on Kouri. They're like, after conferring with our client, we've decided not to. So they're both sort of pointing the finger at the other person, saying it was their idea. But it's all good.
Well, as I said before, whether or not to put on a case is the defense's call. They obviously, Kouri can decide whether or not to testify or not. That's her call. But everything else is the defense lawyer's call. So if they were going to call any other witnesses, that's their call. They decide not to. I respect the call. Big boy pants. I'm here for it.
Poor brothers for Kouri. They wanted to be there to support their sister, and they had to sit out because they were on the witness list for the defense and never got called. So they missed the whole trial and then weren't used. But I guess that's how it rolls. Hey, a couple people are asking questions, Kurt. You're licensed in Virginia and Texas, right, as a lawyer?
Virginia and Texas, yes.
Right. Awesome. And you can argue in front of what?
I'm licensed to practice in front of the U.S. Supreme Court, which is nice, and then the U.S. Federal Circuit, and Virginia and Texas, and I'm currently doing a case in the Western District of Texas. Nice. So I'm licensed a couple places.
Sweet. That's awesome. I will say that
people doubting my credentials over here.
No, they just wanted you to flash your badge a little bit and know who you were.
Oh, okay, that's fine.
I'll say this: we have a portal set up because you're going to do a dramatic reading of the Walk the Dog letter.
Yeah.
Thing. You got a little preview.
Yeah.
I'm not sure if he's going to use the sad piano music or not, but the dramatic reading.
Well, depending on how long you're streaming, I could move the thing up, because I expected there to be more trials, so I scheduled it for the end of the trial day. So depending on how long you want to talk with other people and stuff, I could move the preview. I could move it up.
I'd say move it up. We have a podcast at 8:00 tonight. And I've still got some more tax paperwork I need to find from my accountant. She's so picky. She wants to know everything.
What time works for you?
Yeah. We're probably going to be done here in less than half an hour.
All right. I'll schedule it for 45 minutes. That should be fine.
Okay. Awesome. I've got a redirect going to you, so that'd be great.
All right.
All right. Thanks, Kurt.
I'll talk to you later.
See you.
All right. Bye-bye.
Bye. All right. Let's see. Are you in bad weather? Yes. I took a picture of the map. It's just like red all around me, and we've like gusting, whistling winds around the house. And when the wind goes like that around the house, the wind goes through the house too. That's one of the features of having an old home like this. Okay, here's Selena. Just 1 second.
Call from Selena.
Selena.
Boom.
They rested.
I did not see that coming. Uh-oh.
I teased it, saying it could happen, but I honestly thought they were posturing to bring witnesses, the sending the mom out, everything else. I thought they're really making it look like they're about to call a witness.
Yeah, they must. I am so shocked. I am like, my mouth dropped if you saw me on TV, because I was like,
my eyes were so wide I couldn't see anything but just light when it happened. Complete surprise. I was expecting them to put something on, mostly because they fought so hard to get the ability to put some things on that they want to bring out.
Exactly.
And then
I'm so shocked that they didn't. I don't know what changed.
My issue is at the very end, the state has rested. Their case is over, okay? And they're still playing this back and forth game. We haven't decided yet. The only person that could like throw off is the state. I mean, nobody else. It's not like there's a witness back there who's like, are they going to call me? Are they not? You know, either they do or they don't. The judge could care less if they call. He's just calling the shots, right? But them playing this whole cat and mouse game, Judge, we have a couple options. We're letting them confer, you know, before we tell you who we're going to call next. Why? Why are you still playing that game now? The jury's not even there to see this play out.
Good point. You know what was funny?
What?
Did you catch on the prosecutor then said, well, I want to rest in front of the jury now? Because the judge is like, do you just want me to tell the jury you have, rested, to the prosecutor? But then when the defense said, we rest, then he's like, no, I want to rest now in front of the jury. Yeah. The jury's face, oh my gosh, let me just tell you. They were as shocked as the rest of us.
Man, that is wild. They get the weekend off, so they get to think this over for a little bit. It's been a spicy couple days to end this on. But, the last thing they've heard was Driscoll, and he was a pretty good witness. Walk the dog, that's got to be in their mind.
Yeah, I don't know. Maybe she figures she crossed him it well enough to not need to do any more. I don't know. I don't know what lawyers think. I don't know. But I thought they would do something. I know they had witnesses out there.
I'll tell you that Ms. Lewis looked like she had checked out on this case 2 days ago. And maybe that's because her part was done, really. She was just,
maybe. I don't know.
Chin,
it's crazy.
She was done. Yeah, so I don't know. She must have. I know she's frustrated with how things have gone, with how the evidence has come out, what hasn't come out, and what did come out. But
Kouri's family were in front of us this time today, and her sister started having tears run down her face when they said So they had no idea that until right before they took the family out. And then had him come back in. So I think they told him we're going to rest.
Yeah, I know
but that was just moments before.
When the lawyers were sort of posturing about what we're going to do, who we're going to call, what's up next, we're ready, all that with the judge. Kouri did this like a double take, like what? Looked over at Ms. Lewis like, what did you just say? I thought we had a plan. So Kouri was probably surprised by their posturing as well. Having decided.
So was it like to make the defense think they had something going on, or what? I don't know, but it was nuts.
It can't change anything. I don't know why they're playing that game then. Just like because we can just jerk you around just a little bit, just because we can.
Because we can, maybe. Yeah, I'm like,
to me that
what
shows
the
frustration.
Heck?
It shows frustration with the judge and possibly with the prosecutors.
So
it's
personal. And maybe because he couldn't get that evidence she wanted to get in today without a big, and like you said, it's high stakes poker if you want to go there. And so she decided not to. And maybe that was just like, I don't know. I'm at a loss of what to think.
Well, we have, whatever you think, we have a poll up right now. Asking you if the state has proven their case.
No, I know what
Richins.
I think about.
Okay.
I mean what I think about them resting. Good grief! I wanted to hear some defense, so now I'm like, I can't really answer the poll. I'm flip flopping every which way but loose right now.
Yeah. Well, the numbers right now are, I would say they're not good for the state. Even though that's 72% saying yes, the state's proven the case. 72% is only 3/4, but it's a little under 3/4.
Yeah.
That would be 6 out of 8 if that was if our poll represents the jury. 6 out of 8 would say yes.
Okay. Yeah, I am still sticking with my not enough. There's too much reasonable doubt for the murder charge. And reading some of the jury, like I've been able to do these last weeks, I feel like it could either be a hung jury It could be not guilty. It could be guilty, but I don't think it's going to be a quick deliberation, no matter what.
I will. I'll say this.
What do you think?
I think the closings are going to be very important. I think both sides need to nail it within this closing. I realize closings are not evidence, but they need to tie up the loose ends and to make some of the parts make sense. Some things just got introduced. I'm sorry, Mr. Bloodworth, just showing things on the screen and scrolling through is not the same. It doesn't have the same impact as Mr. Driscoll reading the walk the dog letter had.
Right. Right.
So
they told me to pick something, so I'm going not guilty.
all right.
There's my pick.
Awesome.
Gosh. Yeah, I'll be here Monday. I'll have a few days off. That's going to be fun.
We're going to be back tomorrow just to hear the battle over the
right,
jury
but I'm going to watch
instructions.
that from home. I'm going to be home with you guys. I'll be hanging with my home team tomorrow.
Yeah, with your hubby, who you need to apologize to for outing him for being on the can.
I outed him on.
That's awesome.
He knows.
Greeners has done that to me when I took a break and I was typing something on my phone in chat, and he's like, "Did you take your phone in there with you?" Yeah, so that's.
I was
pretty
so
sure that was
shocked
Greeners.
to see my hubby join. I'm like, what the heck? I saw his name scroll by. And
That's awesome. Welcome, welcome, Warren. Let's see, one more thing. The state closings happening on Monday, defense as well, and so we'll probably be in deliberations by, I'm guessing, early afternoon. We'll be in deliberations.
We're camping out.
Yeah, the defense, having not called any witnesses, basically gets to sum all this up, and they're probably going to be telling the same story they told at the beginning of the case, which was, we're not disputing a lot of these facts. Okay, a lot of these things we admit they happened. We just think that it means something else. So they're both going to be looking at the set of facts and trying to tell two different stories as to what it means and how this all shapes out. And it's going to be spicy. It's their last ditch effort.
Oh,
and
it will. Like you said, there's so much writing on the closing arguments now. They are kind of crucial. So
yeah, I agree. Selena,
but I decided I will come up, and then I'm just going to hang until they say they've sent him home for the night or whatever, so. And
the best part is you're going to be able to give us word that there's a verdict before anyone else knows, right?
Yes, I will.
So that's going to be awesome. Excited
I know, right? You're going to get the inside scoop, and you can get it first.
We can break the
like
news.
I say,
yep.
You can break the news.
And we'll play the verdict
I'm
music
here
and
for
everything.
you.
That is awesome. Selena, thank you very much. Appreciate the call. And we'll be talking to you again soon. Drive
Talk
safe.
to you later.
Yep.
Okay.
Bye-bye.
Bye-bye, everyone. Bye.
All right. We just have a few minutes here. We're going to wrap things up. I'm going to do my taxes, and we'll be back again tomorrow for the fight over the instructions, which could be very, very important depending on what the judge allows them to change. Sometimes the instructions to the jury make or break the case depending on the words and the instructions that are put in. The law doesn't change, but the instructions are extremely important because this is the rule book, the guidebook the jury has on how they go about and deliberate. So I'm excited to hear that and see what is fought over by the two sides, or if they just all agree to the standard instructions and it's done in 2 minutes. Either way, that's going to be interesting. But it sends me no. A tax stream. You guys, there is nothing fun about taxes. Zero fun about taxes. I can tell you last year I made less than the 2 years before. There you go. That's all I know. Did you forget that you already paid your taxes last? All right. Did you forget you already paid your taxes? I paid my property taxes, and I paid my taxes to the government, IRS. I'm hoping to get some of it back. Is the story. Okay, tonight after you go listen to Kurt's reading of the Walk the Dog letter, tonight at 8:00 we have a podcast right here on this channel. I have promised to tell a couple stories, and if you'll remind me when we start, I will tell those stories. And one of them is a massage story, quite recent, quite embarrassing. I'll tell it. One of them is, I think, United Van Rental Moving Company something. I've got a story for that. From mowing the lawn. That's a short one. I thought it was pretty funny. It's basically along the lines of a prank call, and possibly the trees, the FU trees. So that's where we're going. Anything else we need to cover before we get an early break here today? Surprise early break. The woman in purple in the gallery is wearing an EDB laundered shirt. Oh, sweet. That's awesome. Love that she's represented there in the court. Ayden the Wise, welcome to the gallery. Thank you very much. You also gifted a membership. Thank you, my friend. And Kimar says, I'm mad knowing they kept all the fence stuff out. That would have sealed the deal. So the judge's ruling, that was the ruling a long time ago. So that's where it is. I'm just checking chat. Anything else? What was the result of the poll? Great thing. I'll close it now. 71 to 29, I believe. Results are in chat right now. 71 to 29% with 1,300 votes. That is under 3/4. That's just over 7/10. So six out of 8 would convict if we represent the jury. All right. What is Mrs. Aria's take on the case? I haven't told her what happened today. She's been doing school, so not sure. Kouri has a twin? I did not know that. 72. I answered the wrong answer, says Kristen. All right. Whoop, that's the wrong song. There we go. It's on the wrong page. I don't think she has a twin. Does she?
From the state of Georgia.
They're banished. The whole podcast is going to be RA Storytime, and the whole time Thomas is going to be eating these spicy scorpion pepper pistachios. So, we'll see. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. Please stay safe till we go live again. Tonight, 8 p.m. podcast, Not Relevant Podcast, Season 4 episode. I think we're like 9, 10, 11, somewhere around there. It's going to be a lot of fun. I'm looking forward to spending some time with Thomas and with you all. And my utter humiliation is just for your enjoyment. We've got some stories to tell. And then I might have to go dark. I might have to, just change my name and move somewhere where nobody knows me. Greeners has done all the modding today with no electricity, so if you got timed out by him, it's because he's working on a very small phone and has low power, so he can barely see the screen. So, great work, Greeners, and everybody. Thank you very much. Amber, appreciate you. Red Pen as well. Samantha, thank you. All of you are amazing. Be good. Be safe. Have fun. We'll see you in the morning, I think. Oh, wait, are we starting at 1 o'clock tomorrow? We're starting at 1. Here's what we'll do. It's Friday. That means Friday is, if we do any court hopping in the morning, waiting for the Kouri Richins trial to start, it's going to be like landlord-tenant stuff. We'll find something to watch in the morning. Court hopping, then we'll do a separate stream for the afternoon. You guys have fun. We'll see you in the morning. Bye-bye. And tonight as well.
Because he's the guy.
If you could just use your words.